Okay. Good morning, friends, and
Morning, sir.
very warm welcome to today's session. So, today we will be starting with the general subjects. We have already done technical subjects such as approaches, three approaches, and one general chapter that was valuation of real estate. Then we have done cost approach, market approach, and then we have done income approach also. Now we will be starting with the main topic that is general laws. So
Friends, this is a
basically,
very, very important topic and containing 9 marks out of 100. 9 marks, it is a huge score. अगर आपने 9 मार्क का एग्जाम में ठीक कर दिया तो ये आपको पासिंग मार्क के काफी करीब ले जाएगा। तो इसमें सब जनरल चीजें हैं, कुछ भी ऐसा नहीं है। उनका पर्पस आपको यहाँ पर एडवोकेट बनाना या कोर्ट में लड़ाई लड़ना वकील बनाकर नहीं है। उनका पर्पस है एज अ वैल्यूअर आपको क्या क्या एक्ट्स और फैक्ट्स से आपको फेमिलियर होना चाहिए। बेसिक थिंग्स हैं, आप डे टू डे लाइफ में इसको इस्तेमाल करते हैं, और वेरियस थिंग्स विच आर वेरी वेरी इंपॉर्टेंट फॉर एज अ ह्यूमन बीइंग, एज अ पर्सन, एज अ सिटीजन ऑफ इंडिया, क्या क्या जरूरी है और ये आपको आनी ही चाहिए। और इसके साथ साथ आपको 9 मार्क्स का सिलेबस में इसका वेटेज है, तो बहुत इंपॉर्टेंट हो जाता है। प्लीज कंसंट्रेट ऑन दिस टॉपिक, इट इज वेरी वेरी इजी एंड वेरी इजी टू स्कोर इन दिस टॉपिक। यस सर, ओवर टू यू सर, थैंक यू।
thank you, Sandeep ji, for your valuable input. So as far as syllabus is concerned, law is a very vast subject, but we have to concentrate in relation to our profession, that is values profession. The things which are important from values profession, we will be discussing only those things. We will not go in detail in law as far as law is concerned. So as far as syllabus is concerned, you have to study Indian legal system, then salient features of Indian constitution, what are fundamental rights, directive principles of state policy, then what are the different parts of government such as executive, legislature, and judiciary. Then you have to study law of contract. So law of contract, in the law of contract, you have to study formation of a contract, how the law contract is formed, what are the persons who can be a party to the contract, and then what are voidable, and unenforceable contract. Then what are contingent contract, then performance of contract, indemnity and guarantee, and then law of agency you have to study. Then
Sir, can you put it in the slideshow format? थोड़ा बड़ा हो जाएगा so that we can easily read it.
okay, I'll try. Is it okay now?
Sir, it's okay.
It's okay,
Okay.
sir.
Yeah,
Sir,
then
readable.
okay, thank you. Then we have to study tort. What is tort? What are the general principles of tort, and how the tort is affecting the valuation. Then we will study auction. What are the authorities of the auctioneer? What are the duties of vendor, purchaser, and public? What is misdescription and misrepresentation? Advertisements, particulars and catalogs, statements on rostrum, conduct of sale, reservation of price, right to bid, bidding agreement, memorandum of sale, deposit, rights of auctioneer against vendor and purchaser. So this is a topic regarding auction. Then you have to study certain basics of laws of evidence. In law of evidence, you have to study burden of proof, what is presumption and conclusive proof. Then you have to study salient features of insolvency and bankruptcy code to 2016, which is concerning valuation. So from here, these are the things which are related to our valuation profession. Then you have to study certain acts of Companies Act 2013. You have to study certain sections. Mm, particularly, you have to study this section 192 to 231, 1, 2, and 3, 231, 232, 247, and 281, 1. Then you have to study salient features of companies registered values and valuation rules 2017. So here it will be explained who can become a registered valuer, what is the minimum educational qualification, what should be the minimum professional experience, and how you can become a professional registered valuer. And then you have to study salient features of securitization and reconstruction of financial assets and enforcement of Security Interest Act, which is generally called Surfasi Act 2002, concerning valuation. So we have to study this Surfasi Act concerning valuation. So it may be that this act is of 200, 300 pages, but we have to just concentrate the things which are related to our valuation profession. And then in the end, you have to study Section 5N of Banking Regulation Act 1949 on secured loan or advance. So these are the things which you have to study in general law. So it has a huge weightage of 9%. As Sandeep ji have already told you, may be getting at least 9 marks questions out of this topic, general laws. So first of all, we have to study a Constitution of India or Indian Constitution, which all of us know it was adopted on January 26, 1950. And the best thing is it is the longest written constitution of any sovereign country, any independent country. This is the longest written constitution. And from the constitution, you can learn foundational principles that govern the nation and protect citizens' rights. So as far as valuation professionals are concerned, you need to understand constitutional principles because it is very essential for you to understand especially the property rights, contractual freedoms, and rule of the law that underpin your valuation profession. So Constitution of India establishes as a sovereign, socialist, secular democratic republic with a parliamentary system of government. So these are the things you have to learn. SSSD. Four things, four pillars of our constitution. So it creates three distinct branches. The Constitution of India is having three distinct branches: the executive, the legislature, and the judiciary. So each with the defined powers and responsibilities. So these are the three distinct branches. So the Constitution also establish federalism, dividing powers between union government and state government through detailed list specifying legislative competence. So first of all, we will discuss about the preamble of our constitution. So what is preamble? Preamble is basically an introductory statement, or we can say as in the books you have seen, a preface is provided at the beginning of any book. Similarly, this preamble is the introductory statement, which outline documents core philosophy, objectives, and guiding principles. So, preambles are first preamble is justice. Justice means justice, social justice, economic justice, and political justice. Then liberty. Liberty of thought, expression, belief, faith, and worship. You can adopt any faith, you can do worship according to your will. You have the liberty of these things. Then the most important, equality. Equality means equality of status, equality of opportunities to all the pupils of India. And fraternity. Fraternity means assuring dignity of individual and unity of the nation. So this is the important thing. Means both individuals and the unity of the nation has to be assured. These are the preambles of our constitution. So these principles permeate the all Indian laws and inform judicial interpretation, including law affecting property, contracts, and commercial transactions relevant to valuation work. So how these three branches work? Basically, what are the works of legislature? So legislatures basically enact laws as far as the real estate valuers are concerned. If we think it from our valuation profession, so parliament and state assemblies enact property laws. Of course, they can enact any law. So especially if we consider it from valuation point of view, they enact property laws. As you know, RARE Act 2016, it was central legislation, and it requires each state level to implement it in property transactions. This is an example of legislature. And then executive. So as in our case, the implementing authority. In our case, the implementing authority is IBBI. The authorities which implement the laws which are has been enacted by the legislature are called executive. So implement laws through regulatory bodies. IBBI register values and enforces valuation standards under executive authority. And then judiciary. So basic thing is judiciary interpret laws and settle disputes. These are the two works which has to be done by the judiciary. In case of any problem, again about that interpretation of law, it will be done by the judiciary. And of course, you know, for settlement of dispute, you have to go to the court. So court determines, as far as our valuation is concerned, court determine fair market value in land acquisition disputes, creating precedents that guides valuation methodology. So generally in case of LRR, we will discuss what is land acquisition policy. So in case of any dispute regarding fair market value, it has to be determined on the basis of decisions given by the courts. Then what are the fundamental rights? You must be conversant with the fundamental rights. First right is right to equality. These are under Article 14 to 18. It prohibits discrimination and ensures equal protection under law affecting contract enforcement and property right uniformly across all citizens. Then right to freedom. It is given under Articles 19 to 22. It guarantees freedom of speech, assembly, association, movement, residence, and profession. So it is important for conducting business and valuation practice. Or as far as this these are concerned, you can say that these articles are important from valuation point of view. This article 19, this basically says gives details about right to practice any profession, right to practice any profession. So it is a values fundamental right to value or do this practice as a professional is protected under Article 19. But of course, for that you must have a requisite qualification and experience. Means there are certain reasonable restrictions also there. And another thing is Article 300A. So basically, there was Article 31, which was giving a fundamental right of property, but now it has been replaced with the Article 300A. You have to remember that. Article 31 has been replaced with the constitutional right under Article 300A. So it protect against arbitrary deprivation of property without authority of law. Means if the government has to take your property for public purposes, it has to pay certain compensation. For example, let us suppose land has to be acquired in Mumbai for metro expansion. So government cannot take it as it is without paying anything. Government has to pay fair compensation to the owner before acquiring this property. So this is right to property. So right to property, we have already discussed, it has been removed from the fundamental rights by the 44th Amendment, you must remember, in 1978, but it remains constitutional right under Article 300A. Then you know Indian legal system. So Indian legal system is a blend of civil, common, and customary, religious, and corporate law. So there are the structure of Indian legal system is, the top court is the Supreme Court is the topmost court in India, and then High Court. Below the Supreme Court, there are each state has a High Court that deals with the cases under its jurisdiction. A state can have more than one High Court. Then there are district courts. These courts handle civil and criminal cases at the district level, and then there are subordinate courts. These courts include family courts, session courts, and other lower courts that handle specific type of cases. So you need not to go in details of all these, but you must understand these things, the basics of these things. Then from where the law you can get the law. So what are the sources of law? First one is the Constitution of India. The Constitution of India, it is a fundamental legal document that outlines the structures, powers, and duties of government institutions and guarantees fundamental rights of the citizen. And then you can get law from statutes and acts. So these are the laws passed by the Parliament and state legislatures. Parliament of India, there are two parliament, one is Lok Sabha and other is Rajya Sabha. And each state has its own parliament legislation, Vidhan Sabha and Vidhan Parishad. And they are authorized to pass certain laws. So then case laws means on the basis of statutes and acts and Constitution of India, many decisions has been given by the Supreme Court, High Court, and you can make the basis of these decisions, these judicial decisions from Supreme Court and High Court that has set precedents. And then customary laws. There are certain traditional laws and practices followed by the communities. And then certain communities have their personal laws, certain on the basis of their religion. So laws specific to the different communities such as Hindu law, Muslim law, and Christian law, etc. And if we take them examples, then constitutional law. So the Supreme Court's landmark judgment banning the practice of triple talaq in 2017, which is significant step towards gender equality. This is constitutional example of constitutional law. Then civil law. Civil law example is where a case where a tenant sues landlord for not returning the security deposit, which is governed by Rent Control Act. So different types of laws are there: constitutional law, civil law, then criminal law. For example, a case where an individual is prosecuted for theft under Indian Penal Code. That is criminal law. And personal law means a marriage dispute between a Hindu couple resolved under Hindu Marriage Act. Then directive principles of state policy. So what is directive principles of state policy? These are the guidelines for the states to promote social and economic welfare. Although non-justiciable, they are fundamental in governance. So there are certain laws which can be, you can go to the court for interpretation. But there are certain laws which cannot be, you cannot go to the court for interpretations. So they comes under directive principles of state policy. These are the basically the guidelines for the state to promote social and economic welfare. Although non-justiciable, see here it is written, they are fundamental in governance. For example, Article 39 mandates equal pay for equal work for both men and women. And then the Constitution of India, it is provides that India is having federal structures with the unitary bias. Means India is a federal country with the strong central government. State have their own government, but the central government holds a significant power. For example, you know that central government can dismiss a state government in case of breakdown of constitutional machinery under Article 356. Then parliamentary, we are having a parliamentary system of government. So India has adopted a parliamentary system where executive is accountable to the legislature. So who is the executive? As in our case, IBBI is executive, and legislature, central government or state government. So president is head of the state and the prime minister is head of the central government. Whereas in state, chief minister is head of the government and governor is the state head of the state. For example, prime minister and council of ministers are collectively responsible for Lok Sabha. Then universal adult surface. So as according to our constitution, all citizens aged 18 and above have the right to vote, irrespective of their caste, religion, gender, and education. For example, election commission conducts election ensuring that every eligible citizen can participate. So, for example, article right to education, it is under section 21A. This is a fundamental right. It ensures free and compulsory education for children aged 6 to 14. So it is a duty of the state government to implement this fundamental right in their respective states. Then there are certain examples of emergency provisions. The president can declare national emergency in case of war, external aggression, or armed rebellion. So the Indian Constitution, a remarkable document, balances government's rights and justice in a diverse nation. So executive, we have already done that. The branch which is responsible for implementing and enforcing laws. So president or governor, they are ceremonial head of the state and nation. Prime minister, chief minister, they are head of the government. And council of ministers, they are advisors who help in decision making. For example, a Prime Minister of India, along with Council of Ministers, formulates and implements policies and programs for the country. Legislation, they are the branch which is responsible for making laws. Components: Parliament, bicameral legislature at the national level, Lok Sabha and Rajya Sabha, and state legislature, unicameral and bicameral legislature at the state level. So the Indian Parliament passes bills that becomes law, such as recent Farm Bill. Then judiciary, we have already done Supreme Court, High Court, and Lower Court. How they work, basically. So each branch has the power to check others to maintain balance. That is beauty of our constitution. That each branch has the power to check the others to maintain balance. For example, judiciary can strike down laws passed by the legislator that violates constitution, while executive implements law and the legislatures create laws, forming a cycle of governance. So even if a law has been passed by the government or legislature, the judiciary can strike it down if it fails to comply with the constitution or it violates any constitutional law. So these branches ensures a robust and dynamic system of governance, each playing a crucial role in maintaining rule of law and democracy. So this is all about Indian Constitution and certain things related to our valuation profession as far as this constitution is concerned.
Friends, once again, I repeat, the 5 keywords mentioned in the preamble of Indian Constitution. Can anyone tell me the short form to remember, as Dr. Rajvinder sir has already told?
Secular Democratic Republic.
Secular sovereign integrity, integral democratic republic.
सर देखिए, पूरे 5 वर्ड एग्जैक्टली याद रखिए। SSSDR, सॉवरेन सोशलिस्ट सेकुलर डेमोक्रेटिक रिपब्लिक। SSSDR, ट्रिपल एस DR इन शॉर्ट, ट्रिपल SDR। जैसे इंजीनियरिंग में हम लोग याद रखते थे ना, शॉर्ट में आप माइंड में रखिए और आपको पूरा फॉर्मूला याद आ जाएगा। उसी तरह 5 keywords mentioned in the preamble of Indian Constitution, the largest constitution in the world. SSSDR, Sovereign Socialist Secular Democratic Republic. और इसमें 2 वर्ड्स बाद में जोड़े गए हैं। Anyone?
Socialist,
Secular,
socialist and secular.
socialist, secular.
Socialist and amendment.
In which year?
Socialist and
1976.
1975.
76 or 76.
42nd
emergency time.
42nd Constitution.
26.
अरे भाई, इतने सारे ओपिनियन होंगे तो पार्लियामेंट में भी मुश्किल हो जाएगी। एक ही ओपिनियन होना चाहिए ना सबका। अगर अलग अलग ओपिनियन होंगे तो पॉलिटिशियन में और हमारे में क्या फर्क रहेगा? एक ही ओपिनियन होना चाहिए। वी आर स्टूडेंट्स।
It was through 42nd amendment in 1976.
यस। देखिए, इसके बारे में एक लिटरेचर मैंने शेयर किया है। ये आपको एक डिटेल जो लिटरेचर है ये भी शेयर किया जाएगा। इसमें कुछ इंडियन कॉन्स्टिट्यूशन बहुत बड़ा है, लार्जेस्ट है जैसा आपने सुना है, और सबसे इफेक्टिव हमारा डेमोक्रेटिक कंट्री है। और इसमें कुछ चीजें हैं जो इंपॉर्टेंट है रिलेटेड टू वैल्यूएशन। तो क्या क्या रिलेटेड है हम पूरा नहीं पढ़ेंगे। जो रिलेटेड टू वैल्यूएशन है, हमारे इकोसिस्टम से रिलेटेड है, उतना लिटरेचर आपको आज शेयर कर दिया जाएगा आपके ग्रुप में कॉमन सब्जेक्ट्स के अंदर। अभी आपको फोल्डर बन जाएंगे वहां पर, कॉमन सब्जेक्ट्स, लैंड एंड बिल्डिंग एंड प्लांट एंड मशीनरी, अलग अलग फोल्डर्स बन जाएंगे। आपको कॉमन सब्जेक्ट्स का फोल्डर पढ़ना है और अपने एसेट क्लास का पढ़ना है। उसमें डिफरेंट जो फैकल्टी मेंबर्स हैं उनका नाम लिखा होगा। डॉक्टर राजविंदर सर का लिखा होगा। डॉक्टर राजविंदर सर ने अभी आपको यहाँ पर इस सेशन में डॉक्टर राजविंदर सर रिसोर्स पर्सन है, एक्सपर्ट फैकल्टी हैं, फैकल्टी एक्सपर्ट हैं। तो उनके नाम से जो फोल्डर होगा उसमें आपको उनका जो पीपीटीज यहाँ पर पढ़ाई जा रही है वो अवेलेबल होगा। उसके अलावा आपको ऑल्टरनेट फैकल्टी मेंबर्स का भी पीपीटी वहां पर अवेलेबल होगा। यू कैन टेक एडवांटेज। अगर आपके पास फ्री टाइम है, कुछ स्पेयर टाइम आपको मिलता है इतना पढ़ने के बाद, तो फिर आप उसको पढ़ने का आप अपॉर्चुनिटी उठा सकते हैं। ओवर टू यू सर।
थैंक यू संदीप जी। तो नेक्स्ट टॉपिक इन जनरल लॉज इज इंडियन कॉन्ट्रैक्ट एक्ट। So this act was enacted in 1872, which defines contract. Section 2H of Indian Contract Act 1872 defines the contract as it is an agreement enforceable by law. So there are two things here. One thing is agreement, and other thing is enforceable by law. If these two things are there, only then we will call it a contract. You have to remember two things here. One is an agreement and other is enforceable by law. Until and unless it is enforceable by law, an agreement cannot become a contract. So there are two things. There is difference between agreement and contract. You can have agreement, but to make an agreement a contract, you must check whether it is enforceable by law or not. So how a contract is formed? First of all, offer is made. Let us say Mr. A make an offer to Mr. B to sell his car for rupees 5 lakh. That is an offer. And when Mr. B accept that offer, it becomes an agreement. Mr. A offered to sell his car to B. This is an offer, and Mr. B also accept that offer. So there is many things when how the offer can be taken back. We do not need to go in details for that, but as far as we know is concerned, a valuation field is concerned, we must know what is offer and what is acceptance. Then intention to create legal relations. For example, in a commercial agreement, there is an intention to create legal relations such as a business partnership. Then any contract without lawful consideration, any agreement without lawful consideration cannot become a contract. For the contract, there must be some legal consideration. See here A is selling his car to B. This car is a consideration for B. Now Mr. B is paying rupees 5 lakh. In return of this consideration, in return of car, he is paying an amount of rupees 5 lakh. Means both the parties must have some consideration, must give some consideration. Means one party may give his car, second party is giving rupees 5 lakh. One party has done some work for the other party, and other party has paid the work done by the first party. दोनों तरफ से कुछ ना कुछ कंसिडरेशन होनी चाहिए. So lawful consideration. A agrees to sell his car to B for rupees 5 lakh. The rupees 5 lakh paid by B is consideration for the car to A. So B के लिए जो कार है वो कंसिडरेशन होगी, A के लिए 5 लाख है वो कंसिडरेशन होगी. दोनों पार्टीज को कंसिडरेशन मिलनी चाहिए. Second is competence of parties. Competence means both the parties should be legally competent to make a contract. Means both A and B must be of legal age. If minor cannot make a contract, a person with the unsound mind cannot make a contract, or a person who is disqualified by the court to enter into a contract cannot make a contract. So A and B must be of legal age, they must be of sound mind, and none of them must be maybe disqualified by law to enter into a contract. This is competency of the parties. Then free consent. Both the parties agrees without coercion, undue influence, fraud, or misrepresentation. For example, if the developer conceals pending litigation on the land, consent is vitiated. So see here, free consent means consent should not be made under any coercion or under any influence or fraud or misrepresentation. For example, A agrees to sell his car to B without any coercion, undue influence, fraud, misrepresentation, or mistake. Or if let us suppose a builder conceals pending litigation on the land, then this consent is vitiated. It cannot become a part of it. This cannot become a contract. Then lawful object. Purpose of the contract must be legal. A contract to carry an illegal activity is void. Means if you have make a contract to kill someone, such as Supari killing, that is not a valid contract. That is void. Then not expressly declared void. For example, a contract to commit crime is void. So these elements ensures that a contract is legally binding and enforceable by law. So I think this thing is clear to all of you. Any doubt you can ask. So circumstances when consent is not free. This is very important. Consent is not free when caused by coercion, undue influence, fraud, misrepresentation. Then we call this agreement as voidable. And if it is done by mistake, then this agreement is called void. So now we will discuss what is voidable contract and what is void contract. Void contract means if you make a contract with a minor. If you make a contract with a minor, then this contract will be void or voidable.
Void, sir.
It is void. So it is basically called void ab initio. Means कि स्टार्ट से ही ये void है, स्टार्टिंग से ये हो ही नहीं सकता. It cannot become a contract if you make a contract with some person who is minor, then this contract is void. Then voidable is means let us suppose Mr. A has placed a gun on Mr. B to sell his car to him. Means under caution. Mr. B was under caution. Then Mr. B can revoke this, go to the court and say that I have done this agreement under caution. I do not want to sell my car. Means one party has the right to revoke this contract. Means this contract can become void at the instance of one of the parties. That contract is called voidable.
सर जब तक वो उसको नहीं करते, पार्टी दो पार्टियां मंजूर करती हैं, तो वाइड वैलिड रहेगा या
देखिए सर, वाइड जो है वो तो शुरू से वाइड ही रहेगा. माइनर के साथ आपने किया वो वाइड रहेगा शुरू से. वाइडेबल में क्या है कि दोनों ए ने बी के ऊपर गन ताल दी कि मेरे को अपनी गाड़ी बेच दी.
सर वाइड एंड वाइडेबल बोथ आर सेम?
नहीं, वाइड क्या है? वाइड शुरू से ही वाइड है, वो हो ही नहीं सकता. आप एक माइनर के साथ कॉन्ट्रैक्ट कर ही नहीं सकते.
इंसेप्शन इट इज वाइड.
इंसेप्शन से ही, स्टार्ट से ही वाइड है. ये जो एग्रीमेंट है वाइडेबल में क्या है कि उसने क्वेश्चन के अंडर उसने गन पॉइंट पे कहा कि मेरे को अपनी गाड़ी बेच दे. अब बी जो है पहले तो कॉन्ट्रैक्ट करने को राजी हो गया, सब कुछ लिखा पढ़ी हो गई, कॉन्ट्रैक्ट बना दिया, लेकिन बाद में वो पुलिस के पास चला गया कि मेरे को धक्के से ये बोल रहा है कि मेरे को गाड़ी बेच दे. तो ये जो है वो लीगली ले नहीं सकता वो गाड़ी. बी की मर्जी है, देना तो दे दे, कोई बात नहीं. अगर नहीं देना चाहता, पुलिस के पास जाता है, कोर्ट में जाता है, तो वो कॉन्ट्रैक्ट जो है वो वाइडेबल हो जाएगा.
देखिए, आप पुरानी फिल्मों में देखते थे, लास्ट में विलेन किडनैप करता था और बोलता था आप ये प्रॉपर्टी मेरे नाम कर दो, नहीं तो मैं इसको गोली मार दूंगा। दैट इज कॉल्ड कोerशन। इट इज अ वेरी इंपॉर्टेंट टर्म एंड एमसीक्यू कैन बी आस्क्ड। तो उस विलेन को याद करिए, रंजीत होते थे या अजीत होते थे या देयर प्रेम चोपड़ा होते थे। देयर आर सो मेनी विलेन्स इन द
फिल्म
फिल्म
चोपड़ा होते
इंडस्ट्री।
थे आमतौर पे। जी
तो वो
सर।
लास्ट में आपको किसी किसी फिल्म में पुरानी फिल्मों में ज्यादातर यही होता था कि आप इस पर साइन कर दो नहीं तो मैं गोली मार दूंगा, या आप उसको किडनैप कर लिया मैं ये करूंगा वो करूंगा, है ना। दिस इज कॉल्ड कोerशन। तो वो जो अंडर कोerशन अगर आप साइन कर रहे हैं, दैट इज कॉल्ड, अभी जो आपको सर ने बताया है। ओके, थोड़ा माइंड में ये रखिए, कोerशन मीन्स undue influence either through gunpoint or it can be any other pressure also. Over to you, sir. Thank you.
तो वाइड वाइड कॉन्ट्रैक्ट में जैसे कोई unauthorized, if an unauthorized person is selling a government land to you, whether you know it that it is a government land or not, it is void from the starting. You cannot sell a government land. Or we can say that an agreement to sell a property whose title is with the third party. कोई और मालिक है, लेकिन हेमंता राव जी ने ये कह के ये प्रॉपर्टी मेरी है, ये सुरेंद्र जी के साथ एग्रीमेंट कर दिया कि मैं आपको सेल करूंगा। जो चीज हो ही नहीं सकती, जो एग्रीमेंट कॉन्ट्रैक्ट हो ही नहीं सकता, दैट इज void contract. Voidable, it is valid until the aggrieved party chooses to void it. जब तक बी, जो ए ने बी के ऊपर गन तान दी, तो वो वैलिड है जब तक बी नहीं चाहता कि मैं पुलिस के पास जाऊं। ठीक है ना। जब बी चाहेगा कि मैं पुलिस के पास जाऊं, जब until the aggrieved party choose to void it due to coercion, under influence or fraud. For example, a seller conceals that the property is in a litigation zone. The buyer can rescind the contract upon discovering this misrepresentation under section 90. ऑनर को पता था कि मैं जिस लैंड पे बिल्डिंग बना रहा हूं, ये इसका केस कोर्ट में चल रहा है। उसने बिल्डिंग बना के किसी के साथ कॉन्टेक्ट कर दिया कि मैं सेल करूंगा। अब जब वो खरीदने वाला था, उसको पता चल गया कि मैं ये प्रॉपर्टी नहीं ले सकता, मिस रिप्रेजेंटेशन से मेरे को दी गई। सो दिस विल बिकम फ्रॉड, और दिस विल बिकम voidable contract. क्लियर है व्हाट इज void एंड voidable? किसी को कोई डाउट है तो पूछ लो।
सर वाइडेबल कॉन्ट्रैक्ट की कोई टाइम लिमिट भी होती है क्या? लाइक एज 2 साल बीत गए तो उसके बाद
इसका कोई voidable कॉन्ट्रैक्ट का, एक बार तो गाड़ी खरीद के आप ले गए, फिर तो कोई लिमिट नहीं है। गाड़ी आपने नहीं बेची, उसको दी ही नहीं, देने से पहले ही पहुंच गए आप, फिर मैंने गाड़ी नहीं बेचनी, पुलिस के पास पहुंच गए कि मेरे से धक्के से ले रहा है, कोर्ट में चले गए। जब ले ही गया फिर क्या करोगे? वैसे तो इंडिया में आपको पता है कि ऐसा होता भी नहीं है।
जब तक वो लेके नहीं गया तब तक ये वॉइड
नहीं
और
सर, देखिए,
जब तक वो वैलिड है,
वैलिड है।
वो वैलिड है। जब वो लेके चला गया पुलिस के पास, तो वॉइड हो जाएगा। अगर कॉन्ट्रैक्ट जो है इंप्लीमेंट ही हो गया,
लिमिटेशन पीरियड हर कॉन्ट्रैक्ट में
वैलिड
होता है।
वॉइड
देखिए सर, वी विल स्टडी दिस इन द फोर्थकमिंग स्लाइड्स। देयर इज अ लिमिटेशन पीरियड इन एवरी टाइप ऑफ परचेज और कॉन्ट्रैक्ट। ओके, फॉर
वो भी
प्रॉपर्टी it may be some years. For immovable property it may be different. For other things it may be different. For a job purpose it may be different. Up to which limitation period you can file a case against, you can file a suit against that. This term is called as limitation period. हर चीज का एक लिमिटेशन पीरियड होता है। अगर आपसे किसी ने परचेज कर लिया या धक्के से ले लिया, जबरदस्ती ले लिया, तो आप कितने टाइम के अंदर आप उसको कोर्ट में जाकर आप बता सकते हैं। अभी आपसे ले गया, आप 4-5 दिन, 6 दिन, 7 दिन, 10 दिन, 15 दिन, 2 महीने, 4 महीने सोचेंगे, इससे ज्यादा आप जाएंगे तो दैट मीन्स आपकी इंटेंशन पे जाएगा ना, भाई आपसे 5 महीने पहले आपसे प्रॉपर्टी ले लिया, आप 5 महीने बाद आ रहे हो, अभी तक क्या कर रहे थे आप? तो आपसे लेकर वो चला गया, तो लेट इट बी प्रॉपर्टी लेकर भी चला गया। कार है, जैसे सर ने बताया, कार है, ज्वेलरी है, कोई डायमंड्स है, वट एवर इट इज, जो भी है, आपसे लेकर चला गया या आपसे साइन कराकर चला गया प्रॉपर्टी के पेपर्स पे। तो उसके बाद आपको 2 4 5 10 10 दिन के अंदर अंदर आपको एक लिमिटेशन पीरियड दिया जाता है कोर्ट की तरफ से, हर वो प्रॉपर्टी टू प्रॉपर्टी अलग अलग आइटम टू आइटम फिक्स है। तो आपको उससे टाइम के अंदर वहां पर डिस्प्यूट करना है। अगर रेंट कंट्रोल एक्ट के अंदर, रेंट के अंदर देखिए, अगर कोई टेनेंट अगर खाली नहीं कर रहा तो आपको एक पर्टिकुलर टाइम पीरियड के अंदर अंदर आपको कोर्ट में जाना होता है खाली कराने के लिए। देयर आर सो मेनी थिंग्स रिलेटेड टू दिस, वी विल नॉट गो इन डिटेल, लेकिन रिलेटेड टू वैल्यूएशन जो जो है वो हम आगे आने वाली स्लाइड्स में पढ़ेंगे। थोड़ा सा पेशेंस रखिए, आगे आने वाली स्लाइड्स में सब कुछ क्लियर होने वाला है। यस सर, ओवर टू यू सर।
So next is formation of contract. A contract is formed when there is an offer by one party. See here how the contract is formed. There is an offer by one party, then there is acceptance by the other party, and consideration is there, means something of value exchange between the parties. So three things are involved: offer, acceptance, and consideration. And then parties must have intention to create legal relations. Now, who can be the parties? We have already discussed the parties to contract must be competent to contract, meaning they must be of legal age, sound mind, and not disqualified by law. So, void contract we have already discussed. So, void contract is that one is not legally valid and therefore cannot be enforced by either party. Such a contract has no legal effect on the outset. For example, a contract for sale of illegal drugs is void because the subject matter is illegal. It is void from the starting. Neither party can enforce the contract in a court of law. Next is voidable contract. A voidable contract is initially valid and enforceable but can be declared void by one of the parties due to certain legal reasons. This party has the option to either enforce or void the contract. उस पार्टी के पास ऑप्शन है, वो चाहे इसको इन्फोर्स कर दे या इसको वॉइड कर दे कॉन्ट्रैक्ट को। कॉन्ट्रैक्ट, for example, contract signed under duress. If a person is forced to sign a contract under threat, the contract is voidable at the option of the coast party. They can choose to either fulfill the contract or declare it void. Misrepresentation, for example, if a party misrepresents a material fact, the other party can void the contract. For example, if seller falsely claims that car has never been in an accident, the buyer can void the purchase contract upon discovering the truth. So time period, as Sandeep have told you, there is a limitation of time period in which you can make the contract void. If it is under duress, under threat, under caution, or misrepresentation, fraud, etc. Then next is unenforceable contract. The third type of contract. The unenforceable contract is one that is valid, but cannot be enforced due to certain legal technicalities. कॉन्ट्रैक्ट तो वैलिड है लेकिन कुछ सर्टन लीगल टेक्निकलिटीज की वजह से वो कॉन्ट्रैक्ट जो है वो इम्प्लीमेंट नहीं किया जा सकता, वो इन्फोर्स नहीं किया जा सकता। जैसे लैक ऑफ रिटन फॉर्म, फॉर एग्जांपल ए वर्बल एग्रीमेंट टू सेल लैंड। आपने एक लैंड सेल करनी है, आपका वर्बल एग्रीमेंट ही हुआ, तो वो इन्फोर्स नहीं किया जा सकता इन ए कोर्ट ऑफ लॉ। और अगर आपने एक प्रॉपर्टी 1 करोड़ की है, आपने एक एग्रीमेंट किया है 100 रुपीज के स्टैम्प पेपर पर, और प्रॉपर्टी की वैल्यू 1 करोड़ है, तो इट कैन नॉट बी इन्फोर्स्ड इन ए कोर्ट ऑफ लॉ बिकॉज minimum stamp duty has to be paid, or you have to pay the indeficient amount in the court of law, or in certain cases expired statute of limitation, if the time period within which contract can be legally enforced has expired. As Sandeep ji have already told you, this is statute of limitations, that contract becomes unenforceable. For example, a debt collector tries to collect a debt after the statute of limitation has passed. The contract is unenforceable even though the debt still exists. आपने किसी से पैसे वापस लेने थे, लेकिन आपने 5 6 7 साल कुछ उसके बारे में कुछ भी नहीं किया, तो that limitation period has passed, so that is called statute of limitations. So under these conditions, the contract is not enforceable. Next is a contingent contract. So contingent contract, it depends upon the occurrence and or non-occurrence of a specific exam. For example, an insurance policy is a contingent contract. The insurer pays out only if the insured event occurs. आपने गाड़ी की इंश्योरेंस की, वो एक कॉन्टीजेंट कॉन्ट्रैक्ट है, जब तक एक्सीडेंट नहीं होगा गाड़ी का तब तक इंश्योरर ने आपको कुछ भी पे नहीं करना।
कंटीजेंट मतलब कंडीशनल। आप याद रखिए, अगर एग्जाम में इससे रिलेटेड क्वेश्चन आता है, कंटीजेंट कहीं भी वर्ड नजर आता है तो आपके माइंड में एक ब्लिंक करना चाहिए कंडीशनल। अगर कॉन्ट्रैक्ट में कोई भी कंडीशन लगा है देन इट मे बी अ कंटीजेंट कॉन्ट्रैक्ट, कि इतने बजे ये काम होगा तो मैं इतने पैसे दूंगा, तो कंडीशन लग गया। अगर जैसे लाइफ इंश्योरेंस में है, अगर आपने प्योरली लाइफ इंश्योरेंस लिया है, उसमें मेडिकल क्लेम वगैरह कुछ नहीं है, तो बोलेंगे भाई आदमी मरेगा तो पैसा देंगे, पहले थोड़ा देंगे। या फिर अगर एक्सीडेंटल है तो एक्सीडेंट होगा तो पैसा मिलेगा। कंटीजेंट, इट इज अ कंटीजेंट कॉन्ट्रैक्ट। अगर आप मेडिकल क्लेम ले रहे तो आपको पर्टिकुलर अगर कोई इलनेस कवर है तो वो इलनेस होगा तो पैसा मिलेगा, और उसमें भी सर्टेन कंडीशंस एंड अदर थिंग्स आर देयर। तो अगर वो लीगली इन्फोर्सेबल है या नहीं है, आप वैसे ही बोल दें सर मुझे तो ये बीमारी है, देयर आर सो मेनी थिंग्स, वी विल नॉट गो इनटू टू मच डिटेल। लेकिन कंटीजेंट का मतलब आप याद रखिए कंडीशनल। अगर कोई भी कंडीशन लगा हुआ है किसी भी कॉन्ट्रैक्ट में, इट मे बी अ कंटीजेंट कॉन्ट्रैक्ट। ओवर टू यू सर।
So next is misrepresentation. So there is difference between misrepresentation and fraud. We will learn it with an example. Misrepresentation means a false statement. False statement that induces other party to enter into a contract. For example, if a seller lies about the property's flood history to make a sale, the buyer may rescind the contract and seek damages. This is called fraud. Misrepresentation. जैसे गाड़ी का मेरा कभी भी कोई एक्सीडेंट नहीं हुआ, कह के गाड़ी सेल कर दी, बाद में पता चला कि गाड़ी एक्सीडेंटल थी, दैट इज मिसरिप्रेजेंटेशन। एंड फ्रॉड मीन्स इंटेंशनल डिसेप्शन टू सिक्योर अनफेयर गेन। फॉर एग्जांपल, सेलिंग ए कार विद टेम्पर्ड ओडोमीटर। आजकल तो नहीं होता, पहले ऐसे होता था कि गाड़ी का ओडोमीटर जो है वो पीछे कर देते थे टेम्परिंग करके। सो selling a car with tempered odometer constitute fraud. The buyer can void the contract and claim damages. Then how a contract can be terminated? Termination of contract. First thing is performance. If both the parties have performed their part of the contract, then we can say that contract has been terminated. Means both the parties has fulfilled their obligation. Means delivery of goods and payment as agreed. गुड्स की डिलीवरी दे दी और पेमेंट मिल गई, कॉन्ट्रैक्ट खत्म हो गया। सेकंड इज एग्रीमेंट, कि दोनों पार्टीज ने एग्री किया कि अब आगे हम नहीं चलाना चाहते कॉन्ट्रैक्ट को, म्यूचुअली एग्रीड हो गए टू एंड द कॉन्ट्रैक्ट बिफोर completion. Both the parties decide to cancel the contract before completion. And then, due to breach, if one of the party fails to fulfill their obligation, a contractor, for example, a contractor fails to complete a project on time, allowing the client to terminate the contract. Then frustration. Frustration means contract becomes impossible to perform. A venue is destroyed by fire, making it impossible to hold an event. आपने कॉन्ट्रैक्ट किया किसी जगह पे एक इवेंट करना था, लेकिन वो वेन्यू जो था फायर में डिस्ट्रॉय हो गया, तो वहां पे तो इवेंट हेल्ड ही नहीं हो सकता. दैट इज कॉल्ड फ्रस्ट्रेशन. Then what are the remedies of breach? If someone has breached just certain clauses of the contract or has not fulfilled the clauses of the contract, then what are the remedies? First one is damages. Damages means compensation for the loss. A contractor paid damages for not completing a job. Then specific performance. In such certain cases, court can order to fulfill the obligation. For example, a seller must transfer the property as agreed. Court can order the seller to transfer the property as it has been agreed. Then injunction. Injunction means stopping, basically. To stop someone from doing something which is given under the order of the court. Injunction. Court order preventing action. Injunction means court order preventing action. For example, a court stops a party from breaching a non-complete clause. Then
देखिए
recession.
हम लोग सुनते हैं कभी कभी इन लोकल लैंग्वेज के कोर्ट ने स्टे दे दिया है, स्टे दे दिया है. तो बेसिकली स्टे क्या है? इट इज अ फॉर्म ऑफ इंजेक्शन, इट इज इंजंक्शन. ओके, द करेक्ट वर्ड टू बी यूज्ड इज इंजंक्शन. स्टे का मतलब इंजंक्शन होता है, ये अपने माइंड में रखिए. यस सर.
Then recession. Cancelling the contract and returning the party to their pre-contract position. For example, a buyer returns defective goods and the seller refunds the payment. Then performance of contract. So what is performance of contract? We have already discussed that the completion of agreed term by both the parties involved in the contract. Both are, we can say, all the parties. There may be more than two parties involved in a contract. So a company delivers the product on time as per the contract. Then what is indemnity and what is guarantee? There are two things. One is indemnity and other is guarantee. So many times you have to give an indemnity bond. What does this mean? It means indemnity means compensation for loss or damages. For example, insurance policies, these are indemnity. In case of loss, the compensation will be given. As in, at the time of getting your basement plan approved from the corporation, you have to give a indemnity bond. That in case there is damage to any adjacent building, I will be responsible and I will pay for the damages. That is indemnity. Then guarantee. Guarantee means promise to fulfill another's obligation. Yeah. मिस्टर ए ने लोन दिया बैंक से, मिस्टर बी ने गारंटी दी कि अगर मिस्टर ए लोन वापस नहीं करेगा तो मैं पे करूंगा एज ए गारंटर. ए पेरेंट गारंटी से चाइल्ड स्टूडेंट लोन. स्टूडेंट अगर वापस नहीं करेगा स्टडी लोन तो मैं वापस करूंगा, दैट इज गारंटी. So you must know the difference between indemnity and guarantee. Next is law of agency. Agency means car agency or any agency. So what is that? One party acts on the behalf of another. कि आप प्रेस्टिज होंडा से गाड़ी लेने गए, अब जो प्रेस्टिज होंडा है वो एजेंट है होंडा कार का, और कोई और है उस. So one party is acting on behalf of another. So that party is called agent, who is acting on behalf of another, and another on whose behalf he is acting, that who is called principal. So a real estate agent negotiate a property deal for the principal, as an example. So next is tort.
And this is a very, very important topic, very, very important topic, and you will certainly get 1 or 2 MCQs out of it. Yes, sir. Over to you.
So first of all, you must understand what is tort. Tort is a civil wrong. So there are two types of cases. One is civil cases and other is criminal cases. So this is a one type of similar cases, similar civil wrong that causes harm or loss to another person. That causes loss or harm to another person, leading to legal liability. For example, it's a way for someone who has harmed to seek compensation from the parties responsible. So जो पार्टी हार्म हुई है वो इसके अंडर कॉम्पनसेशन क्लेम कर सकती है. So examples are negligence. So negligence जो है, imagine a driver who is texting and driving. He hits a pedestrian, causing injury. The driver can be sued for the negligence because he failed to exercise reasonable care. तो एक ड्राइवर कार चला रहा था, कार चलाने के साथ साथ फोन सुन रहा था जहाँ टेक्स्ट कर रहा था, तो उसी के दौरान उसकी गाड़ी जो है एक पेडेस्टेरियन से टकरा गई. अब पेडेस्टेरियन जो है उसको जो इंजरी हुई उसके लिए वो कार वाले से के अगेंस्ट केस कर सकता है, कॉम्पनसेशन क्लेम कर सकता है. Okay, that is one type of tort. Tort number negligence is a type of tort. Second is trespass. If someone enters into your property, trespassing means if someone enters your properties without your permission, so it is called trespassing. Even if it does not cause any physical damage, he has violated your right to exclusive use of your property. Then nuisance. A factory emits loud noises and pollutants that affect a nearby resident. So then residents can sue the factory for creating nuisance as their peaceful enjoyment of their property has been disrupted. And main, you have type of tort is defamation cases. You must have learned defamation. If someone makes false statement about you that damages your reputation, like spreading lies in a community newsletter, you can sue them for defamation. So basically, there are three types of tort. One is wrongful act or omission, as we have discussed, means a breach of legal duty or legal damage. You have violated a legal right of someone for peaceful living by entering into his premises. And for these, all such things, you can have legal remedy, means compensation or injunction is available. So there are two types of things. One is injuria sine damno, and other is damnum sine injuria. This thing you have to.
सर पेपर फोल्ड करो प्लीज.
हाँ जी. Damnum sine injuria.
Friend, these two terms
Damaging
are very,
without
very
legal.
important. These three terms mentioned on the screen are very, very important. Damnum sine injuria and injuria sine damnum. दोनों में देखने में एक सा ही लगता है, उल्टा पुल्टा लगता है, लेकिन ये बहुत बहुत इंपॉर्टेंट है और इसके ऊपर काफी एमसीक्यूज आ चुके हैं. एक सिनेरियो दिया होगा, जैसा सर ने यहाँ पर बताया आपको, एक सिनेरियो दिया होगा, नीचे लिखा होगा ये कौन सा सिचुएशन है, ये डैमनम साइन इंजूरिया है या इंजूरिया साइन डैमनम है, और दो तीन और भी लिखे होंगे. तो आपको उसमें से करेक्ट आंसर देना है. बहुत इंपॉर्टेंट है और इसको डीपली समझना जरूरी है. यस सर, ओवर टू यू. थैंक यू.
Damnum sine injuria means damage without legal injury. For example, opening a new shop next to an existing one, causing latter to lose customers. The affected shop cannot sue because no legal right was violated. एक स्वीट शॉप थी, उस बहुत अच्छी चल रही थी, उसके साथ एक और स्वीट शॉप खुल गई. अब उसको उसके कुछ पर कस्टमर जो है नई शॉप पे जाने शुरू हो गए. उसको फाइनेंशियल लॉस तो हुआ है, लेकिन उसका कोई भी लीगल राइट डैमेज नहीं हुआ. दैट इज कॉल्ड डैमेज विदाउट लीगल इंजरी. कि अगर कोई भी लीगल राइट डैमेज ना हो,
देखिए,
दैट
लीगल
इज
राइट
कॉल्ड
कब डैमेज
डैमनम.
होगा? अगर वो साथ वाला शॉप वाला उसी का नाम लिखकर उसी का बैनर लगाकर अपना सामान बेचना शुरू कर दे, तो उसका लीगल राइट डैमेज होगा. अगर एक कॉलेज खुला हुआ है, उसके साथ में एक और स्कूल या कॉलेज खुल जाता है और उसके कुछ स्टूडेंट्स उधर जाने शुरू हो जाते हैं, तो ये लीगल डैमेज नहीं है. उसका उसका हक है वहां पर खोलना. इंडियन कॉन्स्टिट्यूशन ने आपको इक्वलिटी का राइट दिया है. अगर आप सेम बिजनेस करना चाहते हैं, कोई आपको रोक नहीं सकता अगर वो बिजनेस रेस्ट्रिक्टेड नहीं है तो. लेकिन अगर वो लीगल उसका राइट खत्म नहीं होता, अगर शॉप के साथ कोई शॉप, स्वीट शॉप, जैसा सर ने बताया आपको, स्वीट शॉप खोल लेता है, आपका स्वीट शॉप चल रहा है, मैं साथ में स्वीट शॉप खोल लेता हूं और कुछ लोग मेरे से गुलाब जामुन लेने आ जाते हैं, तो आप कोर्ट में नहीं जाएंगे, भाई मेरे गुलाब जामुन थे, इसने भी गुलाब जामुन रख लिए, तो ये गलत है, तो ये मैं ही बेचूंगा, ये गुलाब जामुन ये नहीं बेचेगा. नो, इट इज नॉट पॉसिबल. तो अगर, लेकिन अगर मैं आपको लिखूंगा कि मेरा निहार सेठ एंड कंपनी के नाम से है और आपका भी निहार सेठ एंड कंपनी के नाम से ऑफिस है, और मैं भी वही लिखूंगा और निहार सेठ जी का जो लोगो है वो भी मैं लगा लूंगा, तो मेरे लीगल राइट्स हर्ट होंगे. ओ सॉरी, निहार सेठ जी के लीगल राइट हर्ट होंगे, मैंने गलत किया है. तो दिस इज कॉल्ड डैमनम साइन इंजूरिया, डैमेज विदाउट लीगल इंजरी. यस सर, ओवर टू यू.
नेक्स्ट इज इंजूरिया साइन डैम. कि लीगल इंजरी विदाउट एक्चुअल डैमेज. सी हियर, ये उसका उल्टा हो गया, कन्वर्स. such as trespassing in someone's property even if no physical damage occurs. कोई आपके घर में आ गया जबरदस्ती, तो आपका कोई लीगल राइट, कोई हार्म नहीं हुआ, प्रॉपर्टी को कोई फिजिकल डैमेज नहीं हुआ, लेकिन आपका जो लीगल राइट है वो अफेक्ट हुआ. द प्रॉपर्टी ओनर कैन स्टिल सू द इन्वेजन ऑफ देयर लीगल राइट. एंड थर्ड इज विकेरियस लायबिलिटी, means holding one party liable for another's action. For example, an employer being held responsible for the negligent actions of the employee during their works.
अगर आपने कोई एम्प्लॉय रखा है और वो प्रॉपर्टी विजिट कर उससे करा रहे हैं, उससे फोटोग्राफ करा रहे हैं, उससे मेजरमेंट्स करा रहे हैं और आप रिपोर्ट दे रहे हैं, देन इट कम्स अंडर विकेरियस लायबिलिटी। तो ये आपकी लायबिलिटी है, आप साइन करके दे रहे हैं, आप उससे काम करा रहे हैं, इट इज योर विकेरियस लायबिलिटी। तो अगर कोई भी एम्प्लॉयर एम्प्लॉय से काम करा रहा है, तो अगर वो एम्प्लॉय नेग्लिजेंट कोई बिहेवियर करता है, या नेग्लिजेंट कोई स्टेटमेंट देता है, या नेग्लिजेंट या कोई ऐसा करता है जो गलत है, तो वो आप लायबल होंगे उसके भी आप पे। वो नहीं आप बोलेंगे भाई मैं तो 2 साल पहले एक दूसरा एम्प्लॉय देखा था, उसने मेजरमेंट किया था, वो गलत प्रॉपर्टी देकर गया तो मैंने भी उसके ऊपर साइन कर दिया, वो जिम्मेदार है। नो, एज अ एम्प्लॉयर यू आर हैविंग द फुल रिस्पॉन्सिबिलिटी ऑफ योर एम्प्लॉय। यस सर, ओवर टू यू सर।
Then strict liability. Strict liability means liability without fault. For example, a company involved in manufacturing hazardous chemicals can be held liable for any harm caused by those chemicals, regardless of whether they were negligent or not. कि कंपनी में हजार्डियस केमिकल बन रहे थे, वो कंपनी नेग्लिजेंट थी या नहीं थी, अगर कोई लॉस होता है तो वो कंपनी उसके लिए रिस्पॉन्सिबल होगी ही। दैट इज कॉल्ड स्ट्रिक्ट लायबिलिटी। देन न्यूसेंस। न्यूसेंस मीन अनलॉफुल इंटरफेरेंस with the personal use or enjoyment of property. फॉर एग्जाम्पल, आपके घर के साथ किसी ने कोई डेंटिंग पेंटिंग का काम शुरू कर दिया, तो जो एयर पोल्यूशन हो गई, नॉइज पोल्यूशन हो गई, ठक 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 की आवाज आ रही है, पेंटिंग की वजह से एयर पोल्यूट हो गया, so that is nuisance and you can claim compensation for that. And then negligence. Negligence means failing to exercise reasonable care resulting in harm. For example, a driver running a red light and causing an accident. That is negligence. एक ड्राइवर ने रेड लाइट क्रॉस कर दी और एक्सीडेंट कर दिया, the injured party can sue the driver for negligence. So basically, tort law aims to protect individuals from wrongful acts of others and provides remedies for those who suffer harm. How tort is affecting valuation? So we are basically, as a valuer, we are concerned with the valuation part. So first thing is nuisance. When you go to do the valuation of an industry which is causing nuisance, means a factory emits noise and pollutants that affect neighboring residential property. The constant disturbance and potential health hazards can lower the property values in the affected area, as a potential buyer may find the area less attractive. So then negligence. Negligence means you fail to meet your professional standards. A property owner neglects to maintain his building, leading to structural issues such as collapsing of roof or foundation problems. This negligence not only poses safety risk to his property, but it also decreases the property's value due to need of extensive repairs. As far as a value is concerned, if you fail to meet your professional standards, such as inadequate inspection, ignoring comparable sales, not verifying documents, or using an inappropriate methodology, that is negligence on your part. Then environmental contamination. If a property is contaminated by hazardous waste or chemicals, the cleanup cost and potential health risk can severely reduce the property. Property bars must be debted by potential liability and remuneration expenses. Then defamation.
सर एक बार थोड़ा हिंदी में और समझा दीजिए सर इनको, थोड़ा रिक्वेस्ट आपसे।
किस चीज को? देखिए, अगर आप एक वैल्यूअर के पॉइंट ऑफ व्यू से देखते हैं इसको, तो अगर आप वैल्यूएशन करने गए कोई प्रॉपर्टी जिसमें इंडस्ट्रियल प्रॉपर्टी है, वहां पे नॉइज क्रिएट हो रही है, एयर पोल्यूशन क्रिएट हो रहा है, न्यूसेंस क्रिएट हो रही है, जो नेबरहुड्स है उनको प्रॉब्लम हो रही है, तो किसी भी टाइम पे नेबर्स जो है वो कोर्ट में जा सकते हैं उसके अगेंस्ट और कॉम्पनसेशन क्लेम कर सकते हैं। तो दैट विल कम्स अंडर द हेडिंग ऑफ न्यूसेंस, टू यू हैव टू चेक दैट। देन नेग्लिजेंस की एग्जांपल लेते हैं कि अगर आप गए वैल्यूएशन करने, तो अगर आपने अपने प्रोफेशनल स्टैंडर्ड्स ही नहीं मेंटेन किए, इंस्पेक्शन प्रॉपरली नहीं की, कंपेरेबल सेल्स नहीं देखे, डॉक्यूमेंट को वेरीफाई नहीं किया, या वैल्यूएशन गलत तरीके से की, गलत मेथड से की, मतलब लगनी थी इनकम अप्रोच, आपने कॉस्ट अप्रोच लगा दी, तो वो नेग्लिजेंस आपके पार्ट पे हो गई। आपने जिसको वैल्यूएशन दी वो आपको सू कर सकता है। सिमिलरली अगर ऑनर की बात करें, तो प्रॉपर्टी ऑनर ने प्रॉपरली अपनी बिल्डिंग जो है वो मेंटेन नहीं की, नेग्लिजेंस की वजह से प्रॉपर्टी की कंडीशंस बहुत ज्यादा खराब हो गई। तो नेग्लिजेंस किसी भी पार्ट पे हो सकती है, एक एग्जांपल बता रहा हूँ, ठीक है। तो इन्वायरमेंटल कंटेमिनेशन थी, कोई प्रॉपर्टी जो है वो वहां पे एक इंडस्ट्री है, इंडस्ट्री वाले जो कोई प्रोडक्ट था जिसमें केमिकल थे वो वहीं पे डंप कर रहे हैं, तो अब जो नया आदमी आएगा उसको लेगा, तो उसको वो कंटेमिनेशन रिमूव करनी पड़ेगी। रिमूव करने के लिए क्या करना पड़ेगा, उसके ऊपर कुछ खर्चा आएगा, तो वो चीजें आपको देखनी पड़ेगी कि कितना खर्चा आएगा, उसका पोटेंशियल हेल्थ रिस्क कितना हो सकता है।
आप किसी प्रॉपर्टी की विजिट करने के लिए गए इंडस्ट्री की, और वहां पर कंटेमिनेशन आइदर वो डायरेक्ट डाल रहा है गवर्नमेंट डिस्पोजल में, या फिर बिना ट्रीट करे डाल रहा है, या फिर डंप कर रहा है, या कोई ऐसा चीज बना रहा है जिससे आसपास एनवायरमेंटल पॉल्यूशन या एनवायरमेंटल हजार्ड्स हो रहे हैं, तो आप उसकी वैल्यू देते वक्त वो चीज डिटेक्ट करेंगे, वो पार्ट के अगर ये क्योर करेगा, क्योरेबल है या नहीं है, पहले तो ये देखेंगे। दैट वी विल लर्न इन डिटेल इन एनवायरमेंटल इश्यूज रिलेटेड टू वैल्यूएशन, दैट इज अ पार्ट ऑफ योर सिलेबस आल्सो। यहाँ पर अभी इतना याद रखिए, अगर एनवायरमेंटल कंटेमिनेशन हो रहा है, दैट इज आल्सो कंसिडर्ड एज अ टॉट। यस सर, ओवर टू यू।
एंड defamation defamation means if someone has made a false statement about you, such claims of being haunted or having a criminal history can tarnish your reputation। कोई सरकारी कर्मचारी उसके ऊपर रिश्वत लेने का गलत इल्जाम लगा दिया, जिसकी वजह से उसका रेपुटेशन खराब हो गया। और आजकल तो आपने देखा होगा कि बहुत से पॉलिटिशियन दूसरी पार्टी के अगेंस्ट डेफामेशन केसेस कर रहे हैं। So this is an example of tort, defamation. And then encroachment. If a neighboring property owner builds a structure that encroaches onto your land, it can lead to disputes and legal actions, because this encroachment can affect the usability and marketability of your property and subsequently lowering the value of your property. Next is this is all about tort. तो बेसिकली टॉर्ट में कॉम्पोजिशन क्लेम की जा सकती है।
सर टॉर्ट में एक टर्म है ग्रॉस नेग्लिजेंस, नेग्लिजेंस और ग्रॉस नेग्लिजेंस में क्या फर्क है सर?
हाँ जी सर, सॉरी आपकी आवाज क्लियर नहीं।
नेग्लिजेंस और ग्रॉस नेग्लिजेंस में क्या फर्क है?
अर्जुन जो देयर इज सम इंटरफेरेंस इन योर वॉइस, आपके आसपास कोई इलेक्ट्रॉनिक इंस्ट्रूमेंट चल रहा है, उसको बंद करिए और दोबारा से बताइए क्या पूछना चाहते हैं।
Conflict between gross negligence and negligence.
सर नहीं, आपकी आवाज क्लियर नहीं है। आप लिखकर बता सकते हैं, व्हाट्सएप मुझे कर सकते हैं, या फिर आप नीचे चैट बॉक्स है, चैट बॉक्स में जाकर बता सकते हैं। योर वॉइस इज नॉट ऑडिबल, काफी इंटरफेरेंस है, कोई को।
ठीक है संदीप जी, we can have a short tea break of 15 minutes.
Yes sir, yes sir,
We will
yes sir.
continue after 11:50.
Okay, so friends, it is 11:40. We will join sharp at 11:55. We will take a short tea break for 15 minutes. Then we will start the balance topics prescribed for today's syllabus. You can switch off your screens till then.
11:50. Okay, sir.
Yeah, sorry. 11:50. 11:55.
Okay.
11:55.
Okay, sir.
So friends, welcome once again after the morning tea break. We are going to start the session, and before we start, there was a question from one of our participants in the previous session that he want to ask something, and if time permits, I will try to answer his question. Wait for a moment. Mr. Shiv Kumar, Mr. Nikhil Parekh, Mr. Abhishek Anand and Vijay Singh, last call for you before your removal. Okay, goodbye. If you are not following the protocol, you will be removed by the observers. Mr. Akash Deep, last call. Okay, goodbye. And now the meeting will be locked by the observers. So friends, now the question was, what is the difference between, sir, if you are audible? Yeah. The question is difference between negligence and gross negligence. Mr. Abhishek, is it the correct question you want to ask? Mr. Abhishek Mahajan, oh sorry, Arjun Mahajan. क्या यही क्वेश्चन आप पूछना चाहते थे? Yes, Mr. Narendra Pratap Singh ji. Mr. Narendra Pratap Singh ji, am I audible, sir?
Yes, sir.
Sir, can you please read and tell Mr. Arjun Mahajan what's the difference between negligence and gross negligence? Is the screen visible to all?
Yes, visible, sir.
Visible. Okay. Mr. Narendra Pratap Singh ji, please read. Can you please read for all of us and explain?
Yes, sir.
Yes, please. Negligence. What is the definition of negligence? अरे पढ़िए ना भाई.
Definition: negligence is the failure to exercise the degree of care that a reasonable person would exercise under similar circumstances.
Okay, thank you. Mr. Vijaypuri sir, can you please read it again and explain to all of us?
Yes, sir. Negligence is the failure to exercise the degree of care that a reasonable person would exercise under similar circumstance.
Yes, sir. Next.
Like, sir, okay. Just I can add, the sir has explained that if a driver cross the red signal and then hit the person, it is a negligence, if I'm not wrong.
Yes, sir. Next.
Yes, sir.
Exam-oriented points.
Next. Exam-oriented points involves ordinary carelessness. Act is unintentional. Deviation from reasonable standard of care results in civil liability. punishment usually limited to compensation, does not involve reckless behavior.
Yes, sir. Next.
Next is a real life
examples.
example. A shop owner forgets to clean a small water spill and a customer sleeps. A driver momentarily distracted by a phone caused by a minor accident. A nurse forgets to record a patient's vitals on time. A homeowner fails to fix a loose step, causing someone to trip. This is the details of the negligence. And
Yes,
then gross negligence. Definition is gross negligence is an extreme lack of care, showing recklessness, regards for the key safety or lives of others. Exam-oriented points involves very high degree of carelessness, show recklessness on or conscious indifference, act is far below accepted standard of care, may attract civil as well as criminal liability, can result in punitive damages or imprisonment, often treated as almost willful misconduct. And real life examples for this: a doctor performs surgery while intoxicated. A driver races at high speed through a crowded market. A hospital ignores critically safety protocols, leading to patient's death. A factory owner knowingly runs unsafe machinery, causing serious injury. These are the gross negligence.
Yes, sir. Thank you very much, sir. So, key one-line destination for exams. Negligence is lack of reasonable care, whereas gross negligence is lack of even side care, amounting to recklessness. Is it clear? Mr. B. Vinod Kumar. Mr. B. Vinod Kumar, are you there? Mr. B. Vinod Kumar. Yes, sir. Sir, can you please read the below for all of us? Quick memory tip from quick memory tip.
Negligence means carelessness, and gross negligence means it's dangerously carelessness. Negligence versus gross negligence. Aspect negligence, gross negligence. The meaning of negligence is failure to exercise reasonable care that a prudent person would use in similar circumstances. Gross negligence means a serious and extreme lack of care, showing recklessness and disregard for the safety or rights of others. The degree of carelessness is ordinary carelessness for negligence, very high degree of carelessness for gross negligence. Nature of conduct is negligence, it is inadvertent or unintentional mistake. For gross negligence, it is almost willful recklessness or conscious indifference. Standard of behavior for negligence is below reasonable standard. For gross negligence, the standard of behavior is far below reasonable standard. Intent for negligence is no intent to cause harm. For gross negligence, it is no intent to cause harm, but behavior suggested indifference to consequences.
Yeah, now
legal consequences usually lead to civil liability, that is damages for negligence. For gross negligence, it can lead to higher civil damages and in some cases criminal liability. The example for negligence is a driver briefly distracted and causes a minor accident. For gross negligence, example is a driver speeding excessively through a crowded area while ignoring traffic signals. The aspect punishment damages for negligence is compensatory damages. For gross negligence, it is compensatory plus sometimes punitive damages. In simple terms, negligence is carelessness. For gross negligence, it is extreme carelessness bordering on recklessness.
Yeah, thank you very much. So friends, this is the difference between negligence and gross negligence. Sir, Arjun sir, is it clear to you?
Yes, sir.
this sheet will
Yes,
also
sir.
be shared in your study material. Study material देखिए IT टीम ने बिल्कुल अलग कर दिया है, अभी आपको स्टडी मटेरियल थोड़ा ज्यादा मिल गया है, आप चाहें तो उसको व्यू कर सकते हैं, लेकिन ये सेशन खत्म होने के बाद व्यू करिए। एंड सी CEV is an organization of leaders, and here we all are leaders. CEV need everyone to come in the front line to act as a leader. It is not restricted to a small group of persons or organizers. Okay, everyone is a leader in CEV, so you should try to come in front line to act as a leader. Okay, without wasting much time, I would like to request Dr. Rajvinder sir to please start the session after that morning tea break. Welcome back, sir, and namaskar.
Thank you, Sandeep ji, and very warm welcome to all the participants. So we will be starting with our same topic which we were discussing in morning session. We are done third part. Next is Arbitration and Conciliation Act. So this act was promulgated in 1996. So basically, what is arbitration? What this act provides? Basically, Arbitration and Conciliation Act 1996, it provides a framework for resolving disputes outside courts. So in case of contract, if there is any dispute during the execution of the contract, the parties can resolve the disputes outside the courts. So, for example, in case of property valuation professionals, arbitration offers faster resolution of valuation disputes, contract disagreements, and partnership conflicts. So, if a dispute is resolved outside the court, it comes under the heading of arbitration. So, there are basically three types. One is arbitration. Arbitration means domestic arbitration, which is governed by Indian laws. So, as you know, most of the real estate contracts, including there are certain arbitration clause are there in all types of real estate contracts. So, for these, in case of any dispute, to resolve it, a three-member or sole arbitrator tribunals can decide these disputes, and awards are enforceable like court decrees. So one thing you have to remember that arbitration awards are enforceable like court decrees. Second type is foreign awards. So in case of dispute with the foreign company or some foreign Indian company is working in a foreign country, then this foreign award is there. It is enforcement of international arbitration award. It is under New York Conventions and Geneva Conventions. So relevant of cross-border real estate investment and joint ventures with foreign entities. And third thing which comes under arbitration is conciliation. Conciliation is basically a voluntary process where neutral conciliators assist parties in reaching settlement. It is less formal than arbitration. So settlement agreement has the status of arbitral award 2015 and 2019. So first of all, you must understand what is arbitration and what is conciliation. So this act was again amended in 1996. It is called Arbitration and Conciliation Act 1996. So now we will discuss the basic things which are there. First of all, this is a comprehensive statute. This act is a self-contained code covering domestic and international arbitration and conciliation. So the things which are there under New York Convention and Geneva Conventions, they are incorporated in this act itself. You need not to have any other act to deal with international foreign awards. So, for example, this act provides a detailed procedure for conducting arbitration and conciliation, including it gives what should be the qualification of the arbitrator and what is the process of making awards. And then it abolished the umpire system. That abolished umpire system, giving more autonomy to the arbitral tribunal. For example, in a case between two companies, tribunal can make decisions without needing an umpire to break ties. And next is curtailment of court's power. So as we have already discussed that this act limits the supervisory role of the courts, giving more independence to the arbitration proceedings. So courts can only intervene in limited circumstances, such as when there is need to appoint an arbitrator or when there is need to enforce the award given by the arbitrator. Then it has enhanced the powers of the arbitrator. This act has enhanced the powers of the arbitrator. So arbitrators have more authorities to manage and make decisions. For example, an arbitrator can decide on the procedural matters without needing court approval. Then we have already discussed that it has international applicability. The act aligns with the unique UNCITRAL. It is United Nations Commission on International Trade Laws. It has been incorporated in this act itself. So it is a model law on international commercial arbitration, making it applicable to even international disputes. For example, a dispute between an Indian company and a foreign company can be resolved under this act, ensuring international standards are met. And next, provisions for interim reliefs and orders. So this act allows for interim measures to be taken during the arbitration process. Means maybe that this arbitration proceedings takes a very long time. During that times, the arbitrator can allow interim measures. For example, a party can request the tribunal to freeze assets to prevent dissipation during the dispute resolution process. So examples of arbitration case are a dispute arises between two business partners over a contract. They agree to resolve their matter through arbitration. Under the act, the arbitrator hears both the parties and make a binding decision which is binding on both the parties. And a conciliation case, we have already discussed in the conciliation case, two companies in a commercial dispute for conciliation. A conciliator facilitates discussions, helping them reach a settlement. See the difference between arbitration and conciliation. In arbitration, matter is settled by the arbitrator. And in conciliations, a conciliator facilitates discussions, helping them to reach a settlement without going to the court. So this feature makes the Arbitration and Conciliation Act 1996 a robust framework for resolving dispute efficiently and fairly. And the next in your syllabus is auction. So auction law. So first of all, we will discuss, when a property, let us suppose a property is to be auctioned, it has become a non-performing asset, it has to be auctioned. And now we will discuss what are the procedure of auction and what are the duties of auctioneer. what are the duties of vendor? We all things will be discussed in this in these slides. First thing is, what are the authorities of the auctioneer? Auctioneer's authority is that he will manage the bidding process and announce the highest bid and ensure that auction runs smoothly. So you might have seen this auctioneer procedure in a number of pictures also, that the highest bidder is awarded the contract or the property which is under auction. Then it is his duty to enforce the terms and conditions of the auction. Then he has to oversee and regulate the bidding process. And he has the right, he can withdraw or combine items during auction. During auction, he can withdraw certain items from the auction, or he can combine certain items during auction. Then after the finalization of sales, he will issue a memorandum of sale to the highest bidder. Then what is the duty of the vendor? These are the things he can do. But what are the things he cannot do? Authority, these are the things which the auctioneer has to do. But you have to remember that he cannot alter the terms of sales without principal's consent. Second thing is, he cannot give warranties beyond auction conditions. And remember, he cannot accept bids below the reserve price without authorization. You must also remember, if your duties, it also come to what things he cannot do. So then next is duties of the vendors. So duties of the vendor is, you must have to provide a honest and detailed descriptions of the items which are to be auctioned. And in case of a property, he has to provide that it has undisputed title of to the property. He has the undisputed title of the property. Then he has the option to set a minimum price for the items. Then all the necessary legal documents has to be provided by the vendor. As in the case of bank auction, bank is a vendor. He has to do these duties. Second thing is, he has to disclose the defects, inform the potential buyers of any known defects. It is the duty of the vendor. Then what are the duties of the purchaser? Purchaser who purchase a asset during auction, due diligence. It is his duty to inspect the property items which are under bidding before participating in the bidding process. Then he has to adheres with the auction's terms and conditions. He has to make full payment within the specified period. And he has to avoid fraudulent activities and bid truthfully. Then not only the purchaser, many times the public also participates in the bidding process. And then what are the duties of the public in such scenario? First thing is respectful behavior. The public must not disrupt the auction process. They must have to adhere the auction guidelines, and they must avoid influencing bidders or disrupting the auction process. Then what is misdescription and misrepresentation there are two things: misdescription and misrepresentation. Misdescription means incorrect or incomplete description of an item, and misrepresentation means false statement about an item to induce bidding. So there are two things: one is misdescription and other is misrepresentation. So accuracy in auction particulars is essential. Misdescription allow purchasers to rescind or seek compensation. So the distinction between material and immaterial description determines the remedies available. So advertisement, particulars, and catalogs. Advertisement means whenever an auction has to be taken place, it has to be publicize the auction details and key items. Auctioneer, it is a duty of auctioneers to publish these things. And then particulars and catalog. So it is a duty of the vendor to provide detailed description and images of the items for sale. Then statement of rostrum means announcement made by the auctioneers to clarify terms, condition, and details of item is called statement of rostrum. Then conduct of sale. Conduct of sale means managing the auction, calling for bids, and ensuring fair play throughout the process. And whenever there is an auction, a reserve price is fixed, below which the items cannot be sold. It is where your expertise are required. Many times when a property has to be auctioned by the banks, they take your services to give them the liquidation value. So that is a minimum price set by the vendor below which the item will or cannot be sold. Then right to bid. Who had the right to bid? Registered participants have the right to bid, place items on the item. So it is not that during the process anyone can enter into the bidding process. First, you have to get yourself registered to make a bid in the bidding process. Only then you have the right to bid. Then bidding agreement. Agreement among bidders to influence auction outcome often illegal. So basically what happens is when there is auction, maybe that some persons involved in the bidding process, they decide that I will buy this property, you will buy this property. That is called syndicate process. So that process is often illegal. Then memorandum of sale. After the bidding process is over, a document confirming the sale and terms signed by the auctioneer and the highest bidder. That is called memorandum of sale. So deposit. Before entering into the bidding process, an initial payment is made by the winning bidder and by all the participants, and then after the bidding process is complete, an initial payment is made by the winning bidder to secure their purchase. That is called deposit. Then what are the rights of auctioneer against the vendor and purchaser? Against the vendors, they can claim agreed commission and fees from the vendor. And against the purchaser, they can enforce the terms of sales and retain the deposit if the purchaser fails to complete the purchase within a stipulated time period. So this is all about arbitration and auction procedure. Next in your syllabus is law of evidence. So what is law of evidence? And in law of evidence, you have to study burden of proof, presumptions, and conclusive proof. What is burden of proof? The burden of proof refers to obligation to prove allegation made in a court of law. It is in India, this is governed by Indian Evidence Act 1872. So in case of civil cases, the burden of proof typically rests with the party making the claim. The party who is making the claim, the burden of proof rests with them. They must prove their case on a balance of probability, meaning it is more likely than not in their version that the fact is true. So if you, Mr. A has made a case against Mr. B on certain things, then it is the duty of the Mr. A to prove the things. The burden of proof lies on Mr. A. For example, in a breach of contract lawsuit, the plaintiff, the party which is claiming the breach, it must demonstrate that first thing is, see here, first of all, they have to prove that a valid contract exists. Then they have to prove that defendant breached the contract. And third thing, that the plaintiff suffered damages as a result. So it simply doesn't mean that Mr. B has breached the contract. First thing, he must prove that a valid contract existed. Second is the defendant has breached the contract. And the third thing, the plaintiff suffered damages as a result. So the plaintiff can present evidence such as the contract itself, correspondence, and financial records. Then criminal cases, in case of criminal cases. In criminal cases, see in civil cases, it is a duty of the plaintiff. Criminal cases such as in the case of theft, in case of murder, it is a duty of the prosecution. Burden of proof lies with prosecution. So you must understand the difference. In civil cases के केस में जो प्लेंटिफ है, जो कोर्ट में गया, जिसने डिफेंडर के अगेंस्ट केस किया, वो अपना एडवोकेट, अपना लॉयर लेके आएगा और उसकी ड्यूटी होगी वो प्रूव करे. लेकिन अगर कोई मर्डर हुआ है, कोई थेफ्ट हुई है, क्रिमिनल केस हुआ है, तो उस केस में जो ड्यूटी होगी वो पब्लिक प्रोसिक्यूटर जो होगा वो प्लेंटिफ की तरफ से केस फाइट करेगा. ऑफ कोर्स प्लेंटिफ कैन हैव इट्स ओन एडवोकेट आल्सो, बट इट विल बी द बेसिक ड्यूटी विल बी ऑफ that of public prosecutor. Means duty of the prosecution to prove the things. The burden of proof lies with the prosecution. दोनों में समझ लगी प्रोसिक्यूशन में और प्लेंटिफ में क्या फर्क है? ठीक है. प्लेंटिफ क्या होगा? सिविल केसेस के केसेस में होगा, और दूसरे पार्टी जो होगी वो डिफेंडेंट होगी. तो इस केस में अगर कोई क्रिमिनल केस हुआ है तो उस केस में प्रोसिक्यूशन के ऊपर बर्डन ऑफ प्रूफ होगा. सो द अक्यूज्ड is presumed innocent. See here, the accused is assumed innocent until proved guilty. And the prosecution must prove guilt beyond a reasonable doubt. बहुत बार आपने देखा होगा कि कोर्ट जो है वो बरी कर देती है कि केस जो है इट हैज नॉट बीन प्रूव्ड बियॉन्ड रीजनेबल डाउट. कुछ डाउट है उसने किया है या नहीं किया, तो इट इज ड्यूटी ऑफ द prosecution to prove the case. For example, in a murder trial, prosecution must present evidence showing that the defendant committed the crime. Now see how he can prove that. For example, this could include forensic evidence, witness testimony, and other relevant proof. The defendant does not have to prove their innocence. They only need to create reasonable doubt about the prosecution's case. Then what are presumptions? Presumptions are inferences drawn from certain facts to establish other facts. Presumptions are inferences which are drawn from certain facts to establish other facts. General presumptions are these are inferences that court is required to make unless contrary is produced. For example, you presume ही किया जाता है. तो ये example देखिए. A child born to a married couple is presumed to be legitimate. एक कोई मैरिड कपल है वो कह रहा है कि ये मेरा बच्चा है तो उसको प्रिज्यूम किया जाएगा कि ये लेजिटिमेट चाइल्ड है. बट चाइल्ड ऑफ द हस्बैंड, द presumption can be challenged. See here, presumption can be challenged with the evidence showing otherwise, such as DNA testing. वैसे तो ये प्रिज्यूम ही किया जाएगा कि उसका फादर जो है वो हस्बैंड ही है, लेकिन एक डीएनए के थ्रू इसको चैलेंज किया जा सकता है. प्रिजम्पशंस को ये प्रिज्यूम ही किया जाएगा कि ये सच ही है अदरवाइज, बट इट कैन बी challenged. That is general presumption. Then second type is conclusive presumptions. These are the inferences that cannot be reverted. See here, it can be reverted. In general presumptions, it can be reverted. It can be challenged. But conclusive presumptions कौन सी है? Which cannot be reverted, which cannot be challenged by evidence. For example, section 79 states that the person is deemed to be unsound mind if they are declared so by a competent court. अगर किसी कोर्ट ने डिक्लेयर कर दिया कि एक पर्सन जो है वो अनसाउंड माइंड का है तो उसको आप चैलेंज नहीं कर सकते. तो दोनों में फर्क पता चल गया आपको, जनरल प्रिजम्पशन में और कंक्लूसिव प्रिजम्पशन में. फॉर एग्जांपल, इन सम लीगल सिस्टम्स, individuals who attain the age of certain age, usually 18 or 21, are conclusively presumed to have the capacity to enter into contracts. These presumptions cannot be challenged by claiming immaturity or lack of understanding. अगर किसी मेजर ने कोई कॉन्ट्रैक्ट किया है तो वो प्रिज्यूम किया जा सकता है कि वो he has the capacity to enter into contracts. You cannot challenge that कि उसमें मेच्योरिटी है या he has lack of understanding. This is called conclusive presumption. So general presumptions को आप चैलेंज कर सकते हैं, conclusive presumptions को आप चैलेंज नहीं कर सकते. Clear? Next is conclusive proof. Conclusive proofs, similar to conclusive presumptions, those proofs which refers to the evidence that is so strong that it cannot be contradicted or rebutted. Same conclusive presumptions, similarly conclusive proof, कि जिसको आप चैलेंज नहीं कर सकते, रिबट नहीं कर सकते, कॉन्ट्राडिक्ट नहीं कर सकते. फॉर एग्जाम्पल, certain documents such as public document and the contents of a document produced as a evidence of fact which is of a public nature are considered conclusive proof. कुछ ऐसे डॉक्यूमेंट जो पब्लिक नेचर के हैं, गवर्नमेंट ने पब्लिश किए हैं अंडर सेक्शन 57 or 58, they cannot be rebutted and they are considered as a conclusive proof. And then what is certified copies of public records? A certified copy of birth certificate is considered as a conclusive proof of birth details, as it contains such as date of birth, place of birth. This document cannot be disputed with otherwise evidence, with other evidence. So you must understand what is burden of proof. In civil cases, who burden of proof lies with the plaintiff. In criminal cases, burden of proof lies with the prosecution. Then there are general presumptions which can be rebutted, conclusive presumptions which cannot be rebutted, conclusive proof which cannot be rebutted. Next in your syllabus is registered values rules 2017. This is also under section 247, as we have already told you. So many things you already know about this act, but we will go through the contents of this act. Registered values and valuation rules 2017. Eligibility and registration, you know.
Sir, screen is not visible, sir.
Anji?
Please share it again, sir. Screen is not visible.
देखता हूँ क्या प्रॉब्लम हो गई है. Maybe there's some problem.
Yes, sir. Yeah, now it is visible, sir.
Okay, sir, मैं try करता हूँ इसको पहले.
Yes, sir. It is visible, sir, now. So, friend, this is very, very important. Section 247 of Companies Act, Registered Values and Valuation Rules, 2017. It is added in 2017 in Companies Act 2013.
Is it okay now?
Yes. Each and every line, each and every word, each and every topic of this section can be MCQ in your examination. It is very, very important, not only for examination purpose, but for... Am I audible now, sir?
Yes, sir. Now you are audible.
So, friend, this is very, very important section, salient features of companies, registered valuers and valuation rules. It comes under section 247 of Companies Act 2013. You can download it from MCA, Ministry of Corporate Affairs website, as well as from IBBI website. This is very, very important. Each and every word, each and every line, each and every topic of this section can be an MCQ in your examination, not only for an examination purpose, but this section is very, very important for you, for daily professional life, as well as for as a professional career as a registered valuer. Yes, sir. Over to you. Thank you, sir.
So, first thing is eligibility and registration. So, as a you must have a minimum quality in your respective category. If you are applying for land and building, you must be civil engineers. Civil engineer means graduation in civil engineering with the professional experience of 5 years. Means you must have done BTech from an approved AICTE institute or university, or an equivalent qualification as prescribed in the Constitution. Or if you have done graduation, you must have an experience of 5 years. But if you have done post-graduation in evaluation, then this experience is reduced to 3 years instead of 5 years. Means if you have done master in real estate valuation, you can apply to become a registered valuer if you have an professional experience of 3 years. So similarly for plant and machinery, you must be graduate in mechanical engineering, or you have master in plant and machinery. And in case of security and financial assets, you must be CA, CS or ICWA with 3 years experience, or MBA with the MBA finance with 5 years experience. So this is the basic qualifications to become a registered valuer under IBBI. Then there are 3 asset classes, you know. One is land and building, other is plant and machinery, and third one is securities and financial assets, as we have already discussed. Then these acts provides rules, valuation standards Valuation standards are, these are the rules that specify standards and methodologies to be followed for conducting valuations. Then code of conduct. So valuers are, once you have become a valuer, a registered valuers under IBBI, means after clearing for becoming a registered valuer, first of all you have to become a member of a RVO, registered valuer organization. First you attain minimum qualification and experience. Then you become a member of a registered valuer organization. Then you undergo a training of 50 hours, which is called mandatory educational program, which you are doing right now. Then you have to pass an examination conducted by IBBI with minimum 60% marks. Then you can apply for registration with IBBI. You will submit certain document, you will pay requisite fee, and once you become a registered valuer under IBBI, then you have to keep this code of conduct. You have to maintain this code of conduct. Code of conduct means valuers are required to adhere to a code of conduct that ensures ethical practices. For example, registered valuers must not accept gifts or hospitality from clients that could influence their valuation reports. Then recognition of registered valuer organizations. These rules provides for the recognition of RVOs that can train and certify valuers. For example, an organization like CEV Integral Appraisers Foundation, it is recognized as a RVO. Then punishment for non-compliance under this act. If you are not practicing as a registered valuer without a proper registration, it is prohibited and punishable. If you are a person found valuing asset without registration can face legal actions and penalties. And then you have to maintain transparency and accountability. Registered valuers must maintain transparency in their reports and disclose any conflict of interest. For example, a valuer must declare that if they have any financial interest in the companies whose asset they are value, it is their duty. Then next is Companies Act 2013. So you will at least one question from this salient features of registered valuers and valuer organization. Another thing you have many times a question is asked that the record of valuation is to be kept for at least 3 years, or in case there is a legal dispute, then you have to keep that record until that dispute is settled. Many times this question is asked, or you may have been asked at least one question from the salient features of companies, registered valuers and valuation rules. And then you will get one question from this companies at least one question. This is very small part from where you will definitely get one question. First, so you don't need to go through all the sections of this act, Companies Act. The acts only which the only sections which are mentioned in your syllabus, you need to go through them. First one is section 192.2. This action deals with loans to the directors, that how the loans can be given by the companies to its directors. So any times you get any question, any statement regarding this loans to the directors, you can say it is from section 192.2. So there may be two types of question. One, there will be a statement will be given to you. You have to check from which section it is. Or a section will be given to you that then you have to make what is the exact statement, correct statement about this act. So you will get at least one question from these two types. So we will discuss what is section 192 subsection 2. It addresses the loans to the directors and related transactions. So it states that contracts in which contractors are interested must be entered only when consent of board of directors in a board of meetings, and such contracts and related party transactions shall be referred to the board's report along with the justification for entering into such a contract. कि अगर कोई बोर्ड डायरेक्टर के साथ कोई कॉन्ट्रैक्ट किया जाता है, चाहे लोन दिया जाता है या उसके साथ कोई कॉन्ट्रैक्ट किया जाता है कंपनी का, तो उस कॉन्ट्रैक्ट को बनाने से पहले बोर्ड ऑफ डायरेक्टर्स से परमिशन लेनी पड़ेगी. वो चीज बोर्ड ऑफ डायरेक्टर्स में डिस्कस होगी. उनका जब कंसेंट होगा, ओनली देन कॉन्ट्रैक्ट कैन बी एंटर्ड विद द डायरेक्टर्स ऑफ द कंपनी. दिस इज अंडर सेक्शन 192 सबसेक्शन 2. So in cases में while not explicitly requiring valuation, fair value assessment is simply set when board evaluates whether the related party transactions are in the company's interest or at arm's length transaction. तो वैसे इसमें वैल्यूएशन की जरूरत नहीं है. अगर कहीं बैंक बोर्ड ने चेक करना है कि ये जो ट्रांजेक्शन्स है वो कंपनी के इंटरेस्ट में है और ये जो कॉन्ट्रैक्ट है इसमें जो ट्रांजैक्शन हो रही है इट इज आर्म्स लेंथ ट्रांजैक्शन, तो उसके लिए वैल्यूएशन करवाई भी जा सकती है. तो द कंपनी मीटिंग ऑफ इट्स बोर्ड्स एंड पावर्स रूल 2014 require disclosure of material facts and terms necessitating valuation support for significant transactions. तो इसमें बस एक चीज याद रखनी है इसमें कि ये what is one section 192 subsection 2, it addresses loan to the directors or contract with the directors. तो ये बात याद होगी तो फिर आप कोई भी क्वेश्चन इससे रिलेटेड आएगा तो आप उसका आंसर कर सकते हैं. नेक्स्ट इज सेक्शन 232. These sections governs compromises, arrangements and amalgamation and mergers. अगर कोई
And this is very, very important section. Very important section mentioned under 230 to 232. So this governs compromises, arrangements, amalgamation and merger. इसके लिए वैल्यूएशन की जरूरत है और जब वैल्यूएशन होगी कंपनी की तो रजिस्टर्ड वैल्यूअर की एग्जिस्टेंस अपने आप हो जाएगी. तो यहाँ पर क्या क्या रूल्स हैं, क्या क्या रेगुलेशंस हैं, ये आपको जरूर पढ़ने चाहिए. यहाँ पर आपको बताया जा रहा है, पीपीटी आपको दी जाएगी. साथ साथ में आप एमसीए की वेबसाइट पर जाकर ये रेलेवेंट सेक्शंस जरूर पढ़िए. ये आपके लिए नॉट ओनली फॉर एग्जामिनेशन बट फॉर एज अ प्रोफेशनल लाइफ आपके लिए बहुत बहुत जरूरी है. यस सर, सॉरी टू इंटरप्ट सर, प्लीज कंटिन्यू.
तो these sections, these provisions enable corporate restructuring through NCLT approval, replacing the earlier scheme sanctioning provisions of Companies Act 1956. Valuation is central to these proceedings. So अगर कोई भी proceeding हो रही है 232 के अंडर मींस कॉम्प्रोमाइज के केस में, अमलगमेशन के केस में, मर्जर्स के केस में, तो उसके केस में वैल्यूएशन की जरूरत पड़ेगी ही. 192.2 में पढ़ सकती है, नहीं भी पढ़ सकती, लेकिन 230 से लेकर 232 वहां पे आपको वैल्यूएशन की जरूरत पड़ेगी. तो हम अलग अलग सेक्शन जो सिलेबस में है, पहला सेक्शन है सेक्शन 231 requires notice to the creditors and shareholders proposing compromise. अगर कोई compromise और arrangement हो रहा है तो जो creditors है या शेयर होल्डर्स है उनको नोटिस दिया जाएगा रिगार्डिंग प्रपोजल ऑफ compromise or arrangement. That will be under section 231. 230 subsection 1. Then section 230 subsection 2. It requires majority approval for our class meeting. जिसके रिगार्डिंग मीटिंग हो रही है उसमें मेजोरिटी से ये चीज जो है वो अप्रूवल होनी चाहिए कि more number of persons should approve the decision. Then section 233 subsection 3, it allows NCLT to summon meetings of creditors or its members upon requisite approvals to sanction the scheme. एक बार 230 पहले 230 सबसेक्शन 1 में क्रेडिटर्स की मीटिंग हो गई, उसमें मेजोरिटी ने अप्रूवल कर दी, तो फिर एनसीएलटी जो है वो क्रेडिटर्स और मेंबर्स की मीटिंग बुलाएगा अप्रूवल होने के बाद टू सैंक्शन द स्कीम, जो स्कीम बनी है उसको सैंक्शन करने के लिए, मतलब प्रोसीजर कैसे चलता है. सो देन सेक्शन 236 2 जो है, इट इनेबल्स फास्ट ट्रैक मर्जर फॉर स्पेसिफाइड क्लासेस. तो ये चीजें आपको याद रखनी है. Throughout these processes, valuation reports establishes share exchange ratio, determine fair values of for the dissenters, share and support fairness opinion to the courts and stakeholders. तो इनमें जो सब 230 से लेके 232 तक जितने भी सेक्शंस हैं, उसके अंदर कोई भी प्रोसीडिंग्स होगी उसमें वैल्यूएशन रिपोर्ट की जरूरत पड़ेगी ही. ये चीज याद रखनी है. तो 231 में जो क्या है ये याद रखना है को मीटिंग के लिए 230 सब सेक्शन 2 में अप्रूवल ली जाती है. अप्रूवल लेने के बाद फिर एनसीएलटी मीटिंग कॉल करती है, तो जो डिसीजन हुआ है उसको सैंक्शन करती है स्कीम को. और 232 जो है ये सेक्शन इट इनेबल्स फास्ट ट्रैक मर्जर्स फॉर स्पेसिफाइड क्लासेस. देन the our registration of valuation is also under section 247, but this section contains other things also. First one is prohibition of insider trading of securities. Section 247 of the Company Act states that no company shall directly or indirectly purchase its own shares or other specified securities except by way of specified methods. This is also under section 247. कि कोई भी कंपनी अपने ही शेयर नहीं खरीद सकती, अपनी सिक्योरिटीज नहीं खरीद सकती until it is under specified methods. And then section 281 subsection 1, it deals with the winding up and dissolution of the companies. So procedure of winding up dissolution of the companies, it is under section 281 subsection 1. It provides that where an order has been made for winding up of a company by the tribunal, it shall be duty of the official liquidator to take into his custody or control all property effects or actionable claims to which the company is or appears to be entitled. कि जब एक बार ऑर्डर हो गया वाइंडिंग अप का, तो जो ऑफिशियल लिक्विडेटर है वो अपने कंट्रोल के अंडर ले लेगा जो कंसर्न कंपनी है, जो कंपनी वाइंड अप हो रही है, उसके सभी एसेट्स मींस एक्शनेबल क्लेम्स टू विच द कंपनी is or appears to be entitled. So this provision establishes an official liquidator's authority and responsibility for company assets in winding up procedure. Upon winding up order, all company property vests with the official liquidator for realization and distribution of stakeholders according to.
Section 247 mentioned it is 195. It is misprinted, sir, I think. Instead of section 247, it is 195.
Okay, sir.
Yeah, it is misprinted. Sorry to interrupt, sir. Yes. Yes, thank you.
So next in your syllabus is salient features of insolvency and bankruptcy code 2016 concerning
And this is
valuation.
very important topic. This is also a very important topic, IBC 2016. Very important topic for valuers. And we and you both are sitting here only because of this insolvency and bankruptcy code 2016. इसके अंडर ही आपसे कभी-कभी वैल्यूएशन पूछी जा सकती है, तो आपको पता होना चाहिए क्या-क्या इसके प्रोविजंस हैं, क्या-क्या इसमें क्लॉजेस बनते हैं, क्या-क्या वैल्यूएशन और वैल्यूअर्स से रिलेटेड क्या-क्या इसमें सेक्शंस हैं, डिफरेंट सेक्शंस हैं. वेरी इंपॉर्टेंट फॉर एग्जामिनेशन पर्पस. You will certainly get 1 or 2 MCQs out of it. Yes, sir. Over to you, sir.
First is the maximization of asset value. The primary objective is to maximize the value of a debtor's assets to ensure maximum recovery of debtor. So in case of winding up of the company, liquidation value has to be determined. So primary objective at the time of auction or this process is that to maximum value of the debtor's asset to ensure maximum recovery for the creditors. So during the resolution process, the resolution professional ensures that the assets are valued according accurately to fetch the best possible price. Then next is a transparent valuation process. The code mandate a transparent and credible process to facilitate informed decision making. For example, registered values conduct valuation and their reports are made available to all the stakeholders to ensure transparency. Then liquidation value. What is liquidation value? Liquidation value is the estimated realizable value of the asset if the corporate debtors were to be liquidated on the insolvency commencement date. So, on which date this liquidation value is determined? It is determined many times. This question is asked. On which date the liquidation value is calculated? It is calculated on the insolvency commencement date. For example, a company goes to the insolvency, the liquidation value is determined to understand how much the assets would fetch if sold immediately. Then, what is the role of registered values? First thing is only registered values are authorized to conduct valuation under this code. For example, a registered value assess the value of the company's assets, ensuring that process adheres to the standards set by the IBBI. Then, as a valuer, you have to provide valuation reports, which include different sales value for assets under various scenarios, such as fair market value, realizable value, distressed sale value, liquidation value. For example, a report for a manufacturing plant might include value under normal market conditions as well as if sold quickly in a distressed situation. Then balancing stakeholders' interest. So whenever you are doing valuation, it is your duty that the valuation process aims to balance the interest of all stakeholders, including creditors, shareholders, and employees. For example, the resolution professional ensures that valuation process consider the interest of both secured and unsecured creditors, aiming for a fair distribution of proceeds. Then time-bound resolution. The code emphasizes a time-bound resolution process to avoid delays and ensure efficient resolution of insolvency cases. For example, the valuation process is conducted within a specified time frame to keep the resolution process on track. So these features ensures that the valuation process under the IBBI Code 2060 is fair, transparent, and aimed at maximizing the value of the asset for the benefit of all the stakeholders.
Friends, now we will take SARFAESI Act. You should know, everyone should know the full form of SARFAESI Act, SARFAESI. Securitization and Reconstruction of Financial Assets and Enforcement of Securities Interest Act. Every word has a specific meaning. Securitization and reconstruction of the financial assets and enforcement of Security Interest Act. That is called SARFAESI Act. It is enacted in 2002. Yes, sir. Over to you.
So, as Sandeep ji have told, surface. So what is surface? So it is securitization. First thing, it contains securitization. Second is reconstruction financial assets. And next is enforcement of security interest. So first of all, we will discuss about what is securitization. Securitization, it is a process of pooling various types of financial assets. So basically, what happens कि बैंक्स जो है वो सिमिलर टाइप्स के एसेट्स को एक पूल बना लेते हैं, लोन्स का, मॉर्गेज प्रॉपर्टीज का और रिसीवेबल्स का, एंड देन इट इज कन्वर्टेड इनटू मार्केटेबल. कैसे? वी टेक एन एग्जांपल, ए बैंक बंडल्स टुगेदर होम लोन्स का एक बंडल बना लिया, सेल्स देम एज ए मॉर्गेज बैक्ड सिक्योरिटीज टू द इन्वेस्टर्स को एक मॉर्गेज बेस्ड सिक्योरिटीज की तरह सेल कर देता है. दिस अलाउ बैंक टू रेज इमीडिएट फंड्स टू ऑफलोड द रिस्क ऑफ दोज लोन्स. तो उसको सिक्योरिटाइज, दिस प्रोसेस इज कॉल्ड पूलिंग ऑफ फाइनेंशियल एसेट्स, वेरियस फाइनेंशियल एसेट, इट इज कॉल्ड सिक्योरिटाइजेशन. जैसे बैंक ने होम लोन्स को एक सिक्योरिटी बना लिया, तो सेल कर दिया एज ए मॉर्गेज बेस्ड securities to the investors. This is called securitization. Then reconstruction of financial assets. ये क्या चीज है? Reconstruction of financial assets. Reconstruction involves management and restructuring the non-performing assets to make them profitable again. कोई कंपनीज का अकाउंट नॉन परफॉर्मिंग एसेट बन गया, लोन जो है, तो उसमें उसको रीस्ट्रक्चर करके अगेन प्रॉफिटेबल बनाना, दैट इज कॉल्ड रिकंस्ट्रक्शन ऑफ फाइनेंशियल एसेट. जो एसेट हमारा लॉस में चल रहा है उसको प्रॉफिटेबल बनाना. फॉर एग्जांपल, एन एसेट रिकंस्ट्रक्शन कंपनी buys distressed loan from the bank at a discount and then works on recovering the old amounts by restructuring the debt or selling off collateral. कि एक एसेट रिकवरी कंपनी है, उसने जो लोन डिस्ट्रेस हो गया, खराब हो गया, उसको बाय कर लिया कम रेट पे एट ए डिस्काउंट, फिर उस पे वर्क किया, उसको रिस्ट्रक्चर करने के लिए या तो जो कोलेटरल सिक्योरिटी थी वो सेल करके या किसी तरीके से उसको रिकवर करना है अपने प्रॉफिट में लाने के लिए. दैट इज कॉल्ड रिकंस्ट्रक्शन फॉर financial asset. So you must understand what is securitization and what is reconstruction of financial asset. So ये किस तरीके से वर्क करता है? How it works? So first of all, identification of assets. सबसे पहले assets जो है वो आइडेंटिफाई किए जाते हैं. So financial institutions identify assets which are suitable for securitization and reconstruction. Then pooling of assets. पहले आइडेंटिफाई कि उनको पूल किया. सिमिलर एसेट्स आर पूल्ड टुगेदर टू क्रिएट ए डाइवर्सिफाइड पोर्टफोलियो. Then the pooled assets are converted into securities and sold to the investors. This is called issuance of securities. And then after that, the process of recovery and restructure. For reconstruction, asset recovery company, they work on recovering the assets by restructuring the debt terms or liquidating the assets. So how it benefited the various persons, various entities involved in it. For banks, fees of capital reduce risk and improve liquidity. And for investors, they it provide diversified investment options with potentially higher returns. And for the borrower, they may receive more manageable terms on restructured loan. Then enforcement of security and interest. What is enforcement of security interest? Lender can enforce their security without court intervention if a borrower default. So under this act, this is important thing. कि बैंक के पास कोई सिक्योरिटी है तो उसको कोर्ट में जाने की जरूरत नहीं है. They can enforce their security interest without court intervention. कोर्ट की इंटरवेंशन के बगैर अगर कोई पर्सन लोन नहीं देता. So a bank can seize and auction the property pledged as a collateral without going to the court. And in this case, valuation is to be done by a registered value. So only registered valuers can conduct valuation of the secured assets. A bank hires a registered value to assess the market value of a mortgage properties. So transparent. So what is your duty in such cases? This act ensures transparent valuation process to protect the interest of all stakeholders. For example, the valuation report is shared with the borrowers and the other stakeholders to ensure fairness. Securitization of financial assets means financial assets can be converted into marketable securities which can be sold to the investors. As we have already discussed, a bank securitizes a pool of loans and sell the securities to the investors to raise funds. So these things we have already discussed. What is the role of the asset reconstruction company? They take over the bad loans from the bank and work towards their recovery. And for example, an ARC acquires a non-performing asset from the bank and manages to recover the process. Then central registry for security and trust. The central registry is established to regulate and register securitization transactions. For example, the central registry maintains record of all security interests created on the properties. Then exclusion. This is an important thing you must remember. The agricultural land are not covered under Securitization Act, under SARFAESI Act. That is important thing. This act does not apply to the agricultural land, ensuring that farmers are protected. So a bank cannot seize an agricultural land under SARFAESI Act. Then provision of interim relief. This act allows interim measures to be taken during recovery process. A bank can request the tribunal to free the assets to prevent dissipation during dispute resolution process. So this is what is Securitization Act, SARFAESI Act 2002. And the last topic in this is section 5N, secured loan or advance. So this is section 5N of the Banking Regulation Act 1949. It defines secured loan or advance as a loan or advance that is backed by collateral. कि अगर कोई लोन दिया बैंक ने उसके लिए कोई प्रॉपर्टी मॉर्गेज कर रही है एज ए सिक्योरिटी, तो then this loan will be called secured loan. This means the lender has a claim on specific assets of the borrower in case of default. For example, mortgage loan, a loan taken out of the purchase of real estate where the property itself serves as a collateral. एक आपने प्रॉपर्टी खरीदी बैंक से लोन लेके, तो जो प्रॉपर्टी itself will be considered as a collateral security. So if the borrower defaults, the lender can take the possession of the property. So what does the secured loan mean? Is loan advance on the security of the assets, the market value of which is not at any time less than the amount of the loan. अगर आपने कोई प्रॉपर्टी बैंक से लोन पे ली है, तो प्रॉपर्टी की वैल्यू हायर होनी चाहिए लोन से. तो मिनिमम banks have all banks have their loan to value valuation ratio, that is LTV. So that is secured loan. So what are the key requirements? It should be tangible security with market value. Security value should be greater than or at the least equal times. It should be legally enforceable charge or mortgage. And the property must be marketable and realizable security. So what are the RBI guidelines? According to RBI, banks must value security at least once in 3 years for loan amount more than 50 lakh. Revaluation required if property market declines significantly or borrower defaults. So अगर कोई वैल्यूएशन की या प्रॉपर्टी की वैल्यू 50 लाख से ज्यादा है, उस केस में जहां बोरोवर ने डिफॉल्ट कर दिया, तो उस केस में प्रॉपर्टी की रीवैल्यू की जाएगी.
So friends, as a valuation professional in the ecosystem of valuation professionals, this is the biggest source of generating avenues for your career. As per RBI guidelines, banks must value securities at least once in 3 years. Means bank has to revalue the security once in 3 years. For loan amount 50 लाख से ऊपर कोई भी सिक्योरिटी है, तो उसको 3 साल के अंदर एक बार उसको वैल्यूएशन कराना है, अगर वो बैंक में अंडर सरफेसी एक्ट के अंडर किया हुआ है मॉर्गेज. तो रिवैल्यूएशन रिक्वायर्ड इफ प्रॉपर्टी मार्केट डिक्लाइन सिग्निफिकेंटली और बोरोवर्स डिफॉल्ट. देखिए, 2 और कंडीशन उसमें दी गई हैं. जैसे 2016 में जब डिमोनेटाइजेशन हुआ था, प्रॉपर्टी की वैल्यू काफी कम हो गई थी बिकॉज ऑफ दिस पैरेलल इकोनॉमी. सेकेंडली, जब कोविड हुआ था 2020 में, तब आपने देखा होगा प्रॉपर्टी की वैल्यू काफी कम हो गई. तो उस दौरान बैंक्स ने रेगुलर मॉनिटरिंग करते हुए सभी प्रॉपर्टीज की रिवैल्यूएशन कराई थी. 16 में भी कराई थी, 2020 में भी ड्यूरिंग कोविड पीरियड काफी वैल्यूएशंस हुई थी. So this is the biggest source of generating avenues for your professional career. Yes, sir. Over to you, sir.
So this is all about general laws.
So friend, this is very important topic and contains 9 marks in your weightage of 100 marks. Yes, sir.
So if you have any doubt about any certain part of it, we can discuss it here. किसी को कोई डाउट है तो हम डिस्कस कर सकते हैं.
So friends, if you are having any doubt, कोई क्वेरी है, कोई क्वेश्चन है, कुछ इसके बारे में पूछना चाहते हैं, लॉज जनरल. अभी इसके अलावा आपको लॉज रिलेटेड टू रियल एस्टेट अलग से है, वो लैंड एंड बिल्डिंग के लिए है, दैट विल बी टेकन इन द सेपरेट क्लास. एंड लॉज रिलेटेड टू प्लांटर मशीनरी, वो प्लांटर मशीनरी सेशन में होगा. लेकिन ये लॉज जनरल हैं, जो जनरल सभी के लिए कॉमन है, इन कॉमन सब्जेक्ट्स. दीज आर कवर्ड इन कॉमन सब्जेक्ट्स. So,
ठीक है संदीप जी, this is all about general laws. Now we will discuss our next